My Lord, there are substantive respondents totaling 8 in numbers. On the 2nd of June, when directions were given, we were given 2 hours each. My Lord, the speakers who are now on the floor did not speak before the High Court. In fact, they were not party to the directions that we took on time. My point is this: if the 8 of us will be given 2 hours, as we're entitled to, is it possible we'll conclude this hearing today or tomorrow? It is not. I therefore humbly request that we stick to the directions that were given. If they are supporting the appellants, let them just indicate they're supporting, because it will be an anathema for the county government of Kirinyaga or Kiambu to come here and say they're supporting the president's position. That's just a humble request.
Thank you, Ms. Havi. We have done with the respondents who are supporting the petition, and we are now moving to just hold on, council. Okay. We are now moving to now to the respondents who are opposing the appeal, and we have a total of about 16 who filed submissions, and it is not necessary that all of them address the court substantively. We are going to have a number of the appellants respondents address the court. Remember, when we were giving directions, we say that the court reserves the right to restrict time to avoid unnecessary repetition, because all the issues are cross-cutting. And once, for example, the first to fifth respondent, just as an example, have addressed us, the other respondents who are coming to make submissions in support of the first to fifth respondent's position need not take even half of the 2 hours. And that's why we said each side to organize themselves to determine who is going to address some of these thematic areas. We cannot possibly have each and every respondent having 2 hours. So that is the way we look at it. We have to finish this matter by tomorrow. We have sufficient time to do so. What's your name, counsel?
Your Lordship, my name is George Gilbert. I appear for the 71st respondent.
70?
71st.
Who is that?
Felista Wakesho. I filed my submissions. And I'm coming in support. Sorry, Your Lordship.
You come in?
I'm coming in support of the appellant.
Yes.
And I promise to this court that I will not even ask for the 20 or 30 minutes that my previous predecessor took. I am going to take maximum 10 minutes. Maximum.
Are you addressing us on a different issue, or you're basically highlighting an issue that is already on record?
I'm going to do a very simple highlighting of the Kivuitu case of small relevance. Then I'm going to say something very small on the legislations that were decided that are required by the court for a referendum to proceed, making the referendum unconstitutional because of lack of legislation. I promise I will not take more than 10 minutes, Your Lordship.
Did you file submissions?
Yes, I did.
Can we see your submissions first?
They are dated the 23rd of June.
So, Mr. Gilbert?
Yes, Your Lordship.
We'll give you a maximum of 10 minutes. Start at 5.
I promise, Your Lordship. Now, Your Lordship, as I start my submissions, it is very important that I refer you to the judgment of the Superior Court. The copy I have is found in Attorney General Supplementary Record of Appeal, Volume 1A.
So your opening remark is that you're supporting the...
I am supporting the appeal in its entirety. I am supporting the submissions of all the parties who have come before me.
Okay.
And I associate myself
all
fully.
Right, go now that with the substantive issue.
Now, Your Lordship, I refer you to court framing its issue, which is found at the page 5 of the judgment of the court, basically on the basic structure. In declaration number 2, the court is persuaded to consider chapter 1, chapter 2, chapter 4, chapter 9, and chapter 10 of the Constitution to be the relevant chapters that are part of the eternity clauses or the basic structure of the Constitution. Your Lordship, Article 255(1), A to J, if you look at it keenly, it actually encompasses all the chapters that are represented in that declaration that is sought. That is the position of the court. That was the position of the petitioners in the Superior Court. Your Lordship, it is true to say, as Professor Gidu said yesterday, that in many occasions the terms basic structure, eternity clauses, and unamendable clauses is used like interchangeably. If you look at 4 on the same page 5, it is the same chapter 1, 2, 4, and 9. We submit that the same chapters that are being talked about are the same chapters that appear in Article 255, 1A to J. Now, Your Lordship, what is so special about 1A to J of 255? It picks out of all the preceding 245 articles of the Constitution, the drafters picked special 10 of them, 10 articles, A to J, and said these are basic and core to the principles and values of this Constitution. The people of Kenya saw in their wisdom that 10 of all those articles are very important to this Constitution. What do they say about the 10? They say every other thing save for this 10, you must take it to a referendum. Your Lordship, if you go to 256 on the parliamentary initiative, 5A, they say that you can do anything, but when it comes back to the ones mentioned in 255A to J, go to a referendum. Your Lordship, go to 257.10, Article 257.10. They again say that if you want to touch on the 10 in A to J 255, go to a referendum. Your Lordship, I submit at this moment, there is a reason and a special and specific reason for those A to J in 255(1) being mentioned and say, for these ones, go to the referendum. Now, Your Lordship, I'm submitting that while the framers drafted and Kenyans passed that constitution, they very much understood the historical context of the country and the various attempts to amend the constitution, that they decided to say that these are special. Your Lordship, at this moment I pose the question: what is more important in a constitution than the Bill of Rights? what is more important than the independence of the judiciary? Those are the matters that the framers and the enactors of this constitution say, these are special, but they must go to a referendum. Your Lordship, my predecessor spoke about Kivuitu, and I hope you've not taken it off your desks. In the Kivuitu case, I want to specifically refer you to paragraph 158 and paragraph 159, specifically. Your Lordship, as I do that, it is important that I remind this court that Kivuitu is a three-judge bench of Justice Weldon Korir, Mumbi Gugi, and G.V. Odunga. The judgment was delivered by Justice Odunga.
Please remember your 4 minutes, counsel.
Yes, I know, Your Lordship. 158 says, we agree with the sentiments by Ringera Jerry in Joya 2, that an amendment that upsets the basic structure of the Constitution could not be effected by the Parliament without involving the people. That's what the three-judge bench says. Without involving the people is the important word. So the court realizes that according to it, it thinks those are the basic structures, and you must involve the people to be able to turn the issues in A to J, the matters. They must go to a referendum. 159, this is what the learned judges said. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in Joya 2 case was necessary. They are talking about the history of disrespect for the sanctity of the Constitution. Then they say, this may explain why the people of Kenya are aware of the frequent and frivolous amendments to the repealed constitutions provided in Article 255 of 210 Constitution, that the special core factors of A to J. Your Lordship, paragraph 162 of that judgment, they give an example of the independence of the judiciary. And they say as an example, 255(1)(g) provide for amendments related to the independence of the judiciary, which should be approved by a referendum. So, Your Lordship, is it possible that what is being told to this court as a basic structure is not an amorphous organism put above the Constitution, that again, as we say, as statutes, we look up to the Constitution? Does the Constitution look up to another document that is amorphous, known as the basic structures? In fact, the judges in this court seem to suggest that what they would consider to be the basic structure of a constitution is actually the A to J in 255(1). And they say they can be amended as long as there is a referendum. That's what they say. And they say that specifically and expressly in the places that I've said. Your Lordship, when you retire, look at Kivuitu well. Finally, when you're talking of the rules of if you want to amend, because the court made a finding that if you want to amend through a referendum, it is unconstitutional because their laws for referendum are not enacted. You also see chapter 16 of the Constitution, which talks about amendment, is one of the unique chapters that are not covered in Schedule 5 to be having what I would call constitutional dictates on legislative framework. The 5th schedule has listed very specifically the articles that must be enacted by the dictates of the Constitution: Environment and Land Act, Employment Labor Relations Court, National Land Commission. The one for legislation for the framework for referendum is not one of them, as IBC submitted. However, it is provided for in Section 49 of the Election Act. Your Lordships, 4 seconds back to you. Thank you for your time.
Thank you, Mr. Gilbert. First to fifth respondents, are you ready? Yes.
Now, good morning, my Lord. My name is Mudomi Nkolu.
Good morning.
For the 76th respondent, there is a small housekeeping matter.
Sorry, Mr. Tiankolu, you are for?
The 76th respondent.
You are the one who is beginning the...
No, my Lord, but I have the permission of the President of the Law Society to raise a small issue that is of concern for all the respondents.
Yes.
My Lord, when we came for the case conference on 2nd, paragraph 8 of the order that you issued was to the effect that each of the respondents would have 2 hours, and each of the petitioners, or rather the appellants, would equally have 2 hours. And whereas up to that point, there is no major issue, my Lord, what has transpired so far is that we are hearing this case for the 3rd day.
Mr. Tiankolu, please let us not spend time on that.
Yes, my Lord.
Wait a minute.
Yes.
Some of the respondents who have spoken here, we have given them 20 minutes.
Yes, my Lord.
Not necessarily 2 hours, not necessarily 30 minutes, because they are not saying, they are not making any novel point that has not been made. And we are not going to sit beyond tomorrow. And so, we reserve the right to manage time in such a way that holding the scales of justice in an even manner to both sides, we hear you sufficiently. And the sooner we start with the case, the better, so that if you are the one on the floor, if it is Mr. Havi for the first, the fifth respondents, take your 2 hours, and then we'll determine what time to allocate to whoever comes after you, irrespective of what direction number 8 says, because in the last sentence we say that, however, the court shall be at liberty to limit the time allocated to avoid repetition. We knew that there were almost 81 respondents, but at the time there were not more than 5 or so who had made submissions. Why? Because the other parties, the other respondents, we assumed, took the position that they were going either to support or, they were taking more or less the same position as the one taken by either the appellants or the respondents. So, let us now go to the substance of the appeal.
My Lord, I beg you, grant me just 1 minute to make my point. We are not questioning the authority of the court to manage the time. What we are questioning is the evenness of how the time has played out in court, notwithstanding the directions. And the point we are making is, we scheduled 4 days for hearing this case. We, on the 3rd day, part of it is still being spent hearing the appellant's case. Tomorrow we have scheduled some time to hear another appeal, which is also part of the appellant's case. It would follow, my Lord, clearly if we go that route, it would mean out of the 4 days we have scheduled, about 75% of that time, of the oral airtime in court, will have been spent by the appellant. Remembering also, the appellant still have another right of reply according to your directions. And it is in that context, my Lord, we are very humbly suggesting that even as we acknowledge the court must manage the time, we would very humbly plead with you, if they have spent, say, a cumulative of 20 hours, then give us, all of us, combined an equal amount of time, remembering they have even an extra time, because if we don't do that, my Lord, as we say, it cannot be said, at least not fairly, that we had an equal opportunity between the two sides to ventilate our respective cases. So what I'm saying, my Lord, I know we agreed we'll finish this case, but for me, I would suggest, if only for equality of arms, even if it means my Lord gives another extra day, we know the system has suffered because we have pulled all our judicial resources to handle this matter. But my Lord, I'll remind you what we suggested on 2nd. This is the most important case of our lifetime. If we spend another 2 or even 3 extra days, fine, the backlog will still increase, but it will be time spent in a worthwhile manner. Otherwise, my Lord, if we proceed the way we are proceeding, our concern, and I'm speaking on behalf of all the respondents, is that when you accumulate the total time the appellants and their supporters have had, our time will be way, way shorter, and it's clearly not fair. And of course, my Lord, I leave it to the court.
Mr. Tiankolu, thank you. I've heard your point. And what we have said is this. First of all, I want you to remember that day one, most of the morning was spent on the preliminary issue that we had to deal with. And yesterday, there was a time, almost half an hour, part of the afternoon, that we were not able to sit because of power interruptions. We have not come to the end of the session tomorrow. We have said, let us get going. If by the time we come to the end of the session tomorrow, we still find that there are substantial, substantive parties who must be heard on issues that have not been covered. We'll cross the bridge when we get there.
I'm guided, my Lord, so that I don't waste more time.
Let us now get to the matter.
And my president will take the podium, my Lord.
My Lord, the President of the Court of Appeal, my ladies and my lords, my name is Nelson Havi. I appear together with Esther Angawa for the 1st to 5th respondents in the consolidated 4 appeals. And the respondents are Dr. David Ndii, Jerotich Sei, James Gondi, Wanjiku Gikonyo, and Ikal Angelei. On 27th of August 2010, the people of Kenya promulgated a constitution. It was a perfect charter that defined the system of government. It created a pure presidential system with one executive, unitary. It created a minimum of 14 and a maximum of 22 cabinet secretaries. It created a parliament of 290 constituencies in the National Assembly. It also created a judiciary that was independent and accountable. There are those who have found fault in that constitution. They have proposed a total of 74 amendments. Within the stroke of the pen, which proposal dwarfs a total of 38 amendments effected on the Independence Constitution from 1963 to 1991. Our submissions are structured as follows. I will address the judicial authority over political actions and decisions, the legal underpinning for the basic structure, eternity, and amendable clauses doctrines, amendment and dismemberment, constituent power, popular initiative and constituent power, the President and constituent power, the effect of the Constitutional Amendment Bill 2020 on the basic classes is applicable in Kenya. To that extent, the High Court defined what the basic structure is. It stated that the basic structure is the constitutional core edifice or its essential features. The court further indicated that these two doctrines are identifiable from an examination of the history and the text of the Constitution itself. The court proceeded to say, and this we'll find at page 176 or paragraph 473 of the judgment, and I may quote, "To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable." So the doctrines are explicit. Sorry, they are implicit, they're not explicit. The court proceeded to indicate that insofar as the basic structure is concerned, an alteration is permissible, but only through the exercise of the constituent power. And the exercise of the constituent power was premised upon 4 sequential steps: civic education, public participation, debate, and a referendum as the ultimate process. Now, the question that arises, and which the appellants dwelt upon at length, was that the doctrine of constituent power is not textualized in the Constitution of Kenya and is inapplicable. May I take the court to the decision upon which this doctrine is domiciled in Kenya's jurisprudence? And this is the case of Njoya and 5 others versus the Attorney General. It appears in volume 2 of my bundle at page 642 all the way to page 728. And you will find at page 677, the anchoring of the constituent power. And this is what Justice Aaron Ringera said about the constituent power at page 677. Indeed, it is not expressly textualized by the Constitution, and of course, it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they will do so only ex abundanti cautela, out of an excessiveness of caution. Now, this doctrine did not originate with Justice Aaron Ringera. It is my submission that the doctrine permeates the entire history of democracy. You will find this doctrine elaborated by John Locke in the 2 Treatises of Government. Volume 1 of my submissions at page 247. This is how Locke defines constituent power. He defines constituent power as the power to form government. He proceeds to say constituent power connotes the subordination of the power of the Commonwealth. And the Commonwealth here refers to the civitas, civil government. Baron de Montesquieu, writing about this page 318, identifies that constituent power. It is therefore my humble submission that constituent power is traced to antiquity insofar as democratic governance is concerned. It is not an emergent concept. It is not alien. May I conclude that particular part with what renowned professor of law Ben Nubweze states about constituent power. And you'll find this in volume 2 of my bundle, in particular at page 496. Page 496. This is what Nubweze states at page 496. The chapter is titled Presidentialism and Constituent Power. I will revert to the issue of the president and the constituent power. But in the concluding line of the paragraph, it is a power to constitute a frame of government for a community, and a constitution is the means by which this is done. In essence, therefore, it is the sovereignty. It is my humble submission that with those precise arguments based upon the law, we have founded the existence of the constituent power within the realm of constitutionalism. We need not look any far. Now, having identified the constituent power, we now proceed to consider the legal underpinning for the basic structure, eternity, and unamendable clauses in doctrine. Again, permit me to go back to the Njoya case, where the basic structure doctrine, in my humble submission, finds the first application in Kenya's constitutional jurisprudence. And this is what Justice Aaron Ringera said at page 688. Page 688. I've highlighted it. He says, all in all, I completely concur with the dicta in the Kasevenanda case that Parliament has no power to and cannot, in the guise or garb of amendment, either change the basic structures of the Constitution or abrogate and enact a new Constitution. What was the context in this matter? An entire abrogation of the Constitution was sought on the basis of Section 47 of the retired Constitution. The court said no. For you to alter that system of governance, you must go back to the constituent power. Speaking about the constituent power and the basic structure of the Constitution, and here you recall the question that was posed by Justice Kiage to Senior Counsel George Oraro. Can the people of Kenya, through their majority, resolve to remove or abrogate Parliament? What was his answer? He said yes. Permit me to take you back in history. When is the pivotal moment in the history of the world when this was attempted? It was in 1933 by Adolf Hitler. And history records that of all the European leaders of that time, it is only Adolf Hitler who ascended to power with an overwhelming majority at the ballot. Now, let's see what Justice Aaron Ringera said about that issue. He proceeds. In my judgment, the framers of the Constitution could not have contemplated or intended such an absurdity, the removal of Parliament. And it will not be an answer to that concern to say, as was said by counsel for the second respondent, that the people can't change their Parliament. It is as simple as that. Now, let's domicile the basic structure in text. And I will take you back to Professor Nobweze writing about presidentialism in Commonwealth of Africa, and still on the topic of the constituent power. And permit me to emphasize, when Nobweze writes, it is not a suggestion, it's not a concept. He indicates what the law is. And for those without the benefit of good learning, this is the point. If you go to your library, you will find the common law texts. For instance, we have Chitty on contract. Chitty writes the law. We have De Smith on constitutionalism. De Smith writes the law. We have Gower on company law. They write the law. So that when we find these postulations in the written works, they're not suggestions, they are the law. Now, we go back to page 496, where Nobweze talks about the basic structure. And in particular, you'll find this at page 500 to 501. 500 to 501. If I may go there pretty fast. So we start at 500 at the bottom where it starts as follows. A constitution is supposed to be a permanent charter which is to endure for ages to come and not to be lightly altered to meet the temporary expedience of political parties. And my lords and my ladies, as you pause there, let me take you back to the preamble of the Constitution of Kenya so that the significance of these points may sink. This is what the preamble says in introduction and in conclusion. We, the people of Kenya, then after enumerating all those recitals, says, adopt, enact, and give this constitution to ourselves and to our future generation. Now, if any scholar of law or litigator were to ask you to locate the basic structure doctrine in the Constitution, then the answer will be, can you locate for me the doctrine of separation of powers, checks and balances, and independence of the judiciary? Now, we go on and see how Professor Nobweze has applied this basic structure to the Kenyan situation. And you will find this at page 526 of volume 2. 526, my lords and my ladies, 526. And I've highlighted at 526, but I'll proceed straight ahead to page 527. And the background is this. He has examined all amendments in the Independence Constitution at the time of its writing in 1973. And he has categorized them into two: the strict power of amendment and the power of repeal. And before I read what he has said, he concludes that there is a dichotomy between amendment and repealing. And what in actual fact happened to the Independence Constitution were not amendments, they were a repeal. This is what the renowned scholar of law says. This alternative method that was used initially in Kenya appears to be legally unimpeachable, the alternative method. Since the power to alter the Constitution was rather widely defined to include amendment, modification, or reenactment, with or without amendment or modification. And here is where we underline. However, applied to the Independence Constitution, but not to the Order in Council itself, it may be doubted whether the spirit of the amending power contemplated the destruction through the superimposition of a republican presidential form of the system of government instituted by the Constitution, namely monarchical parliamentary government. The so-called amendment, in fact, established a new constitution, and as such, should have been effected by the repeal of the existing Independence Constitution. He says this in 1973. Is he alone when he says this? No, he is not alone. He is joined by Justice Aaron Ringera many years later. And this is what Justice Aaron Ringera said, commencing from page 688 at the last paragraph. Before I leave this aspect of the matter, let me comment on the previous amendments to the Constitution of Kenya. Since independence in 1963, there have been 38 amendments to the Constitution. The most significant involve a change from dominion to republic status. The dominion was this: there was a governor general, and then there was a prime minister. There was the lower house and the upper house. What we commonly refer as to Madaraka Day is the day that we were given a prime minister. Within 6 months, by December 12th, what we commonly call Jamhuri Day, the Constitution was abrogated to eviscerate the dominion status and install a presidential system. Now, Ringera proceeds. Abolition of regionalism, what we now have as devolution, change from parliamentary to a presidential system of executive governance, etc. And this is how the learned judge, and he was indeed very learned, concludes. The effect of all those amendments was to substantially alter the Constitution, substantially alter the Constitution. Some of them could not be described as anything other than an alteration of the basic structure or features of the Constitution. And they all passed without challenge in courts. My ladies and my lords, before Copernicus, before Columbus, there were many things about the earth that were not known. They are now known. The fact that we did not know something 10 years ago did not mean that we were foolish then. We were not wise. We've just grown wiser. He concludes, all I can say that is, in that respect, is that unfortunately or fortunately, the changes were not challenged in the courts, and so they are part of our Constitution. Now, fortunately for us, the 74 proposed eviscerations on our permanent charter was successfully challenged before the High Court. The High Court agreed with us. It is my humble request that you uphold the finding of the High Court on that issue. I will not be, my Lord, my Lord.
I follow your argument, but I'm just wondering, the wisdom you speak of, past Joya, the Joya decision was in 2004, is it?
2004, my Lord.
2004.
Yes.
He speaks very clearly about the place of the Constituent Assembly, right?
Yes.
Now, when you come to our Constitution, 2010, you have this chapter which talks about, I know you're looking at your watch, yeah, time. It lists those chapters that cannot be, or rather section 1, yeah, that cannot be amended without reference to the referendum. My question is this: why is it that we were able to incorporate the referendum, but we did not include the Constituent Assembly, which now the judges of the court below actually say is an important aspect in that process?
Yeah, my Lord, you're right. Your question is quite germane. And it is partly answered by Justice Ringera, and it is also answered by other scholars. And that is why Justice Ringera said, if we don't have a referendum in our law, it is implicit. Out of abundant caution, we have included the referendum. But, my Lord, let me trace the origin of the constituent power, because it is my humble submission that the constituent power is that which is in us. In French, it is called pouvoir constituant. It is almost traced back to God. It is in the category of what we call inalienable rights. For instance, I have the right to life. You may textualize it in the Bill of Rights. You may not textualize it in the Bill of Rights, but it is my right. Let me give you a more basic example. Childbirth must happen after 9 months. And there's a manner of happening of childbirth. If it is textualized, it is for the benefit of medical learning, but it doesn't change the mode. Have I answered your Lordship?
In a roundabout kind of way, you've attempted. Carry on.
Thank you. My Lord.
Mr. Havi, just on the same issue, what's your view? Were the principles espoused by Ringera J in the Njoya matter realized by Kenya in the making of the Constitution of Kenya 2010?
They were realized to a certain extent. For instance, the referendum was textualized. The constituent power was not textualized. Public participation was also provided for in various aspects, commencing from Article 10, going to Article 118 and 119. But the premise upon which we seek to support the decision of the High Court is this: even if they were not there, we are duty bound to follow them. There is an argument between Princess Anne and President Lyndon Johnson as to the efficacy of the Westminster model vis-a-vis the presidential system in the United States. And Anne told the president, if you are accustomed to mediocrity, you will find fault in perfection, referring to the English system of governance. Because in England, scholars will say that England does not have a written constitution. The fact of the matter that England does not have a constitution, that's the fact. what England has is demonstrable, perfected constitutionalism, so that these doctrines in here, and they apply whether or not they are textualized.
All right, go on.
Thank you, my Lord. My Lord, I will be doing an injustice on that topic if I did not acknowledge the works of Professor Richard Albert on the basic structure, which you will find I have extracted at page 1281. And Richard Albert says this, writing about how courts become supreme in defending the Constitution from unconstitutional amendment. He says that it is the duty of the court to defend democracy. Another writer whose mention requires immortalization for the purposes of these proceedings is Yaniv Rosnai, writing about populist constitutionalism and unconstitutional amendment doctrine. Again, he formulates the doctrine of constitutional capture. And because this is very relevant, permit me to cite and quote in brief what Rosnai states at page 1304 of volume 4. He formulates the concept of constitutional capture by a populist regime or leader. And then he concludes at page 1307, the last paragraph. 1307. This is what Professor Rosnai states. Abusive constitutionalism becomes especially attractive, 1307 at the bottom. Abusive constitutionalism becomes especially attractive with relatively flexible amendment processes controlled by a dominant party or the government. He proceeds, for example, what allowed the weakening checks and balances on the protection of rights in Hungary, effectively turning it into an illiberal state that fails to comply with minimum standards of constitutionalism. Here at home, and it is a pity that the few royal natives like Professor Githu Muigai and Professor Ben Sianya have not brought their works on this issue. Here at home, I'm saying that the royal natives. You see, in England we have the lords, and here we have the professors when it comes to law. So the royal natives, Professor Githu Muigai and Professor Ben Sianya, have not written on this issue. But one royal native has written on this issue. His name is Professor John Mutaha Kangu. Mutaha Kangu. And his book is titled Constitutional Law of Kenya and Devolution. And if you look at volume 4 at page 1276, 1276, this is what the good scholar of law says. The basic structure of the Kenyan Constitution should include the sovereignty of the people, the supremacy of the Constitution, the principle of sharing and devolution of power, democracy, rule of law, the Bill of Rights, especially the right to human dignity, separation of powers, and the independence of the judiciary. And then he concludes, just as the judges of the High Court concluded, that you cannot exhaustively enumerate which clauses in the Constitution to which to attach the basic structure, eternity clauses, or unamendability. He says, nonetheless, implied non-amendable aspects of the Constitution can be identified.
From that, I think the argument was made that if that be the case, the courts would have to be approached at every turn to determine what that comprises. What do you say to that?
My Lord, I listened to that submission with a lot of disappointment. The court need not be approached anytime the amendment is proposed. The reason is this. The court is the final arbiter of interpretations of the Constitution, but not the only one. Under Article 10, everybody is obliged to apply and interpret the law when formulating policy or making a decision. It will therefore be incumbent upon any initiator of an amendment initiative, be it Parliament or Wanjiku, to make that inquiry. And my Lord, this is fundamental because under Article 94 of the Constitution, Parliament's fundamental role is to protect the Constitution. And before I part from that point, this Parliament identified 3 areas of unconstitutional amendments in the bill. 1, the installation of an executive prefect in the judiciary in the name of ombudsman. 2, the manner of creation and allocation of boundaries. And 3, the want of a legal framework to enable amendment. But they nonetheless passed the bill as it is. Why? Because they failed to comply with Article 10 and Article 94 insofar as they obligate. And my Lord, it must sadden you that a legislator will come and tell you here that should we be coming to court every time we want to identify a basic structure? I think I've sufficiently answered that point.
It is not clear what the answer is to. So what is to happen if a proposal is made to amend? How is one to go about determining whether you are tampering with the basic structure or not? How do you make that determination?
My Lord, the determination is to be made by looking at the history of where we've come from. For instance, we have a pure presidential system of government. And upon it is anchored separation of powers and checks and balances. So that when you initiate that amendment, you need to look at the history of the people of Kenya in constitutional making. But should there be need for the issue to be determined in court, it will be determined when it has become germane. Like in our case, the issue was germane. It was not in the realm of conjecture. So that conundrum is one that should not prevail at this juncture. And because I want to leave my colleague with a clear 1 hour, let me quickly deal with the popular initiative and constituent power. Now, I will take you to volume 1 of my list and bundle, volume 1. And here we are again referring to a scholar, a professor of law, Professor Albert Stern, Methods of State Constitutional Reform. And you will find the operative article at page 343. 343. And I rely upon this decision, page 343, it's a written text, to indicate that popular initiative is not peculiar to Kenya. There is a colleague of mine who submitted that we are the only ones who have domiciled this doctrine. If we can look at page 343, this is what Professor Stern says. In America, it is called the Constitutional Initiative. And in paragraph 1, the last 2 lines, it is regarded as an expedient as an expedient which may be utilized in situations where the legislature has failed to act. Substantially, the device amounts to a reservation by the people of the power to alter the basic law in their sovereign capacity without resort to the usual process of legislation through representation. And then Professor Stern proceeds to conclude when he's evaluating the efficacy of the constitutional initiative in the United States of America, and this is what he says at page 60. Page 60 at subtopic evaluation. As a technique of amending the state constitution, the initiative has distinct advantages and disadvantages. On the positive side, one of the most significant advantages of the constitutional initiative is its availability as a popular weapon to combat domination of legislative bodies. And then he concludes in that paragraph, not only is the constitutional initiative a device for avoiding stalemate in the legislature, but it also serves other useful purposes. If properly utilized, it may be a device for popular education of important public issues. An admission was made from this podium by none other than the Attorney General. They are pending before Parliament a total of 22 proposed amendments to the Constitution. One of my colleagues will deal with how the government
or attempts that have been made.
They're still in Parliament, 22, and we have enumerated them in our petition, 22. So therein lies the mischief. You've seen legislators speak here and seek to ascribe to themselves the title Wanjiku. A legislator can never be a Wanjiku. It's as simple as that. And I will conclude with that point when I'm talking about the president and the constituent power. And straight to the point, we'll start with the definitions at Article 260 of the Constitution. Who is a person? Who is a public officer? Who is a state officer? The moment you become president, you cease being a person. You become a state officer. And if there is any doubt as to how you are supposed to exercise yourself, then recourse can be made to 2 or 3 examples. We will start with Locke himself at page 250 of volume 1. Page 250 of volume 1, 250. And this is very imperative. This is very imperative, page 250. And I don't want to read the entire treatise, but if you look at, starting from paragraph 151 at the bottom, this is what Locke concludes about a state officer, the monarch, the executive, who ceases holding his office, a hallowed office. But when he quits his representation, this public will, the protection he enjoys, and acts by his own private will, he degrades himself. He degrades himself. And he cannot come here and complain through the Attorney General of being insulted. And is but a single private person without power and without will, the members owing no obedience but to the public will of the society. Locke proceeds to indicate that doing so amounts to tyranny. He has also defined tyranny at page 272 to 273. But before I examine what Nubweze states about the office of the president and whether or not he can exercise constituent power, permit me to premise the foundation from Article 131 itself. 131. Sub-Article 2A and B. The President shall respect, uphold, and safeguard this Constitution. There is no obligation of that kind on Wanjiku, Atieno, Nasmiu, Hadija, or Mende. It goes at B, safeguard the sovereignty of the Republic. There is no obligation on me to safeguard the sovereignty of the Republic. Now, that is the office of the President. And we have seen what the sovereignty of the Republic is. It is the constituent power. The President, like King David before him, cannot start taking the flock. The President, like King Edward VIII, must remain the President if he wants to engage in the affairs of other lesser mortals. Then he must abdicate. There are no two options to this matter. And to contextualize that quickly, we see what Professor Ben Nubweze says at page 462 of volume 1, sorry, of volume 2. 462 of volume 2. At page 462, writing about the extent and the reality of presidential power, Nobweza says the most striking feature of the presidency in Africa is its tremendous powers. Its formal powers exceed those of its American prototype, not in nature, but in extent. You now realize the lamentation of President Lyndon Johnson when they were having dinner with Princess Anne. And as he closes, this is what he says at page 483. The splendor, that is of the president, page 483, last paragraph. The splendor is indeed part of the social preeminence of African presidents, the splendor. Personifying the state, writes Arthur Lewis, they dress themselves up in uniforms, build themselves palaces, bring all other traffic to a standstill when they drive, hold fancy parades, and generally demand to be treated like Egyptian pharaohs. If Professor Nobweze and Arthur are alive, drive in the streets of Nairobi. The president is not a mere mortal, he is a superior mortal. Now, let me conclude with the effect of the constitutional amendment bill on the basic structure, eternity, and unamendable clauses doctrines.
Sorry, before you read that, Havi, so your submission, following from what you have said,
My Lord.
would therefore be that Articles 27, 38, among others,
Yes.
cannot apply to the president?
The president cannot be party to a popular initiative.
No. I'm talking about Article 27, Article 38, among others.
My Lord, let me just go there. My Lord, they do not apply to the president. And I'll just give you one illustration. Let's look at Article 37. The right to assemble.
No, I'm talking about 27 and 38, among others. Can they apply to the president?
No, they don't apply to the president.
All right.
And the reason is simple, and it's in Article 37. Every person has the right, peacefully and unarmed, to assemble, to demonstrate. Imagine the president demonstrating or picketing.
Supposing, Havi,
My Lord.
supposing the president is president on an independent, as an independent. I think that picture was presented here. And he has a parliament which is running rogue. Can he not make an appeal directly to the people, go to the people who elected him and demonstrate in the streets of Nairobi against that parliament?
A story is told to be, I think it was told to be by retired Justice Kwach or Dr. John Khamenei, that when there was a threat of toppling President Jomo Kenyatta's government, one Chief Justice joined the crowds to demonstrate in the streets of Nairobi, and it was ridiculous. But, my Lord, to contextualize what you're talking about, there is this documentary series, The Designated Survivor, the predicament of an independently elected president of the United States. It is a predicament. It may arise, it may not arise, but the fundamental proposition is this: Kenya is a multi-party democracy. You stand as no ball chance in hell winning the presidency in Kenya as an independent.
Supposing, because that was presented here, supposing Parliament doesn't listen to the President, Parliament has the majorities, and people in this country, people change, right?
Yes, my Lord.
If that happens, are you saying that the President cannot make a direct appeal to the people and join them in petitioning Parliament, for example?
No, my Lord, he cannot. If the president is such a predicament, he has to do which King Edward VIII did. He must abdicate and go and marry the American divorcee. It's as simple as that.
So what is the place of Article 1, Sub-Article 2 of the Constitution? Can Wanjiku speak through a state officer, even the president? Can Wanjiku present a request to a state officer and say that this is my petition, this is my request, can you, consider it and act on it?
My Lord, there is a reason why I refer to Professor Stan to create the conceptual framework of what in America is called the constitutional initiative.
Yes, and link it kindly to Article 1, Sub-Article 2, so that we make an informed decision regarding the question of sovereignty and the people exercising their power either directly or through their democratically elected representatives. Thank you.
My Lord, I agree. The question is quite appropriate. Under Sub-Article 2, the people can act through those two fora, directly or indirectly. When they do so indirectly, they do so through their representatives. When they do so directly, they do so in exercise of their constituent power. When all those other avenues, as Professor Stan says, have failed to yield results. But my Lord, because the... Yes, yes. And my Lord, perhaps now that you've asked that question, the answer that was given by Professor Nobweze may be apt here at page 496. Page 496 of volume 2. Yeah, he says, recalling again that the president under the presidential system in Commonwealth Africa is the organ that coordinates and therefore dominates the executive and legislative process of government, in particular, that it is he who, as executive, has and controls the legislative initiative. We ask the question whether his power in this behalf includes or should include constituent power. And when you progress with that chapter, Nobweze concludes affirmatively that the president can never exercise constituent power. And I may take you even further. Justice Wolfgang. Justice Wolfgang, who is also a professor of law in Germany, says this constituent power was not available to the monarch and is not available to the executive in a republican. No wonder, therefore, Germany had to entrench certain clauses because they couldn't entertain a repeat of what happened in 1933. Now, my lords and my lady, if you permit me to use these 13 minutes.
Yes, you can move on.
I want to interrogate the effects of the BBI bill on the basic structure. This is what the BBI bill has done: to destroy, to dismember, to eviscerate the basic structure of the Kenyan system. It has created an impure hybrid presidential and parliamentary system. And remember, Nobweze spoke about it concerning the change from dominion status to republic. This bill has domiciled the cabinet in the legislature, effectively obfuscating the functions of the executive and of the legislature. They may tell you we can't see separation of powers in the Constitution, but it's there. There is no separation of powers in what is intended. Thirdly, it has sought to interfere with the independence of the judiciary by installing an executive prefect in the name of Bobchinski, aka Ombudsman, to perform functions allocated by the people of Kenya to the Judicial Service Commission. Parliament itself acknowledged this fault. But my lords and my ladies, I would have wanted to speak much about this issue. But it's an issue that now requires retirement. It requires a retirement, and for me to retire, I will quote two people, Nobweze and Justice Ewan Krigler. For Nobweze, I will quote what he says about the mixture of the presidential and parliamentary system, this time specific to Ghanaian founder, Dr. Nkrumah. This is what he says at page 624 of volume 2. 624, my lord. I will take you. Remember, when we were studying GHC and history, we were told many good things about Dr. Nkrumah. But you see, when you study the law, you will understand many other bad things about Dr. Nkrumah. And this is what happens. At page 624, at the tail end of that page, the linkage of the executive to the legislature was reinforced by the provisions requiring ministers to be drawn from the legislature. That is at page 624. However, neither the president nor his ministers were responsible to the legislature. And so there was no question of his being forced to resign because of an adverse vote. My lord, I've spoken about the removal of the checks and balances. This is what I'm talking about. And this is what Nobweze concludes about the good doctor. The tendency to dictatorship, that is at page 625. The tendency to dictatorship of an arrangement which combines in a president full executive power and control of legislation is obvious. It is obvious. It is little wonder, therefore, that Dr. Nkrumah became a dictator under that constitution. And you know what Ghana had to go through for it to attain the stability that it enjoys now. As I conclude, let me again immortalize Justice Ewan Krigler, so that it doesn't come back to Kenya when Kenyans, by their own will or through the propulsion of their leaders, decide that their destination must be hell. It should never happen. This is what Justice Ewan Kriegler said at page 764, page 764. I'm referring to the report of the Independent Review Commission. Report of the Independent Review Commission on the general election held in Kenya. This is what the good judge said.
What volume are you?
That is volume 3, my lord. 3. Volume 3.
Right.
Page 764. The last 2 paragraphs. In order to start trying to prevent a recurrence of the tragic aftermath of the 2007 general elections, and this is where you underline, Kenyans, from president to peasant, will have to do an agonizing stock take of where their country stands. An agonizing stock take. From president to peasant, the pharaonic president who makes traffic stand, to the peasant, the holder, the bearer of the constituent power, pouvoir constituant. They will have to show their commitment to the rule of law and its equal applicability to all citizens, irrespective of economic, social, and political or any other belief. No, the solution does not merely lie in constitutional and legislative changes. The culture of impunity in Kenya needs a fix too. The relevant law enforcement institutions also need to do their jobs properly. IBC must do its job. Parliament must do its job. We have done our job here. My lords, let the court do its job. I plead with you most fervently to dismiss the 4 appeals and affirm the decision made by the High Court. You owe these to the people of Kenya in tandem with the oath you took in accordance with the preamble. I beg to rest, unless there is a question.
Your last exhortation seems to suggest that if we don't agree with you, we are not honoring our oath. But we could go either way. You realize that?
No, my lord, I just asked you to do your job. How you do it, you better qualify to know it.
Absolutely. Thank you.
I'm too junior to be able to do your job. Thank you.
Thank you, Mr. Havi. Who comes after you? It's your colleague.
My co-counsel Esther Ngawa.
Yes, please. Let her
She has
come.
the entire hour
Yeah.
ahead of her.
We joined at 11:15. 11:30. 35 minutes. Mr. Ngawa, please.
Thank you, my lord. Good morning.
You have 35 minutes before we adjourn, then you come back to finish. I know you have an hour. So please proceed.
Thank you, my lord. Good morning, my lords and my ladies. My name is Esther Ngawa.
Yes.
On the first issue, on the quorum of the IEBC, I will not address the court substantively on the issues because our submissions cover them quite at length. However, there are a few points that I would like to bring to your attention following the submissions by the appellants on these issues. And the first, my lord, is on the distinction between composition and quorum of the IEBC. Indeed, His Lordship Justice Kiage did ask whether composition is the same as quorum, and we submit it is not. The composition of the IEBC is provided for under Article 250, Sub-Article 1, alongside other constitutional commissions, as being a minimum of 3 and a maximum of 9. The specific composition of the IEBC was set at 7 by the IEBC Act, and the quorum, which is the number of commissioners required for it to undertake business, was set at 5 by paragraph 5, Schedule 2 of the IEBC Act. Now, my lords, the challenge by the Commission to the findings of the Superior Court on this issue is firstly based on an allegation that the Superior Court misdirected itself because there was no law requiring a quorum of 5. I would like to disabuse that notion, my lord, by looking specifically at the decision claimed to have declared as unconstitutional paragraph 5 of Schedule 2. That decision is Katiba Institute and others versus Attorney General at volume 1, page 154 to 173 of our bundle.
You see the page?
Page 154 to 173. That's the entirety of the decision.
Right.
But I would like, my lords, if you could go with me to page, if you could go with me to page 165 of volume 1.
Yes.
And this is what the court says at paragraph 73 of that decision. The court says, prior to the impugned amendment, and this amendment, my lord, is the amendment introduced by the Elections Laws Amendment Act of 2017, which sought to reduce the quorum from 5 to 3. Prior to the impugned amendment, paragraph 5 of the second schedule to the Act provided that the quorum was 5, stating the quorum for the conduct of the business at a meeting of the Commission shall be at least 5 members of the Commission. After the amendment, the paragraph now provides that the quorum of the conduct of business at a meeting of the Commission shall be at least half of the existing members of the Commission, provided that the quorum shall not be less than 3. Going down to paragraph 77 of that decision, this is what Justice Chacha-Mwita said. Looking at the amendments and reading the Act as a whole, from the definition of chairperson, election of a member to exercise powers and functions of the chairperson, to the quorum of the Commission for purposes of meetings, it is obvious that these amendments have a negative effect and unconstitutional effect to the functioning of the Commission. To the last sentence in that paragraph, with the above in mind and considering the effect of implementing these amendments, I find and hold that the amendments to the IEBC Act are unconstitutional. It is the amendments that sought to reduce the quorum from 5 that were declared as unconstitutional. And my lord, the Senior Counsel, Professor Gideon Muigai, sought to convince the court that the declaration related to the provision that required a quorum of 5 for the commission. And the effect of the declaration of unconstitutionality was to completely remove that provision from the law. Now, my Lord, before I take you to the consequences of declaration of unconstitutionality, let us assume that indeed Senior Counsel Githu Muigai was right on behalf of the Commission. Let us go to the case of Isaiah Biwott, which they quoted, and faulted the Superior Court for ignoring For clarity, Katiba Institute was decided by Chacha Mwita on 6th of April 2018. 6th of April 2018.
It is a page?
Katiba Institute is the one I've just referred to.
No, I'm talking of the other one.
Biwott is 175 to 185 of that bundle. It comes right after Katiba Institute.
All right.
Now, in the judgment in Biwott, where the commission was the first respondent, the first paragraph at page 175 says that, sorry, not the first paragraph, this is page 176, paragraph 2, it says the petitioner's case, which is supported by his affidavit sworn on 6th June 2018, 6th June 2018, after the decision of Justice Chacha Mwita on 6th April 2018. In Isaiah Biwott, the IBC does not take the position that paragraph 5 of Schedule 2 is not law. Because in Isaiah Biwott, paragraph 5 of Schedule 2, prior to the amendment that was declared as unconstitutional, is what is in issue. And my Lord, if you go to page 181, if you go to paragraph 31 of the judgment in Isaiah Biwott, where the court is interrogating that issue, the court asks, is paragraph 5 of the second schedule of the IEBC Act unconstitutional for offending Article 251 and Article 248(2)(c) of the Constitution? The said paragraph provides that the quorum for the conduct of business at a meeting of the Commission shall be at least 5 members of the Commission. Finally, the court decides that the issue before it, which was to declare that the composition of the IEBC was unconstitutional and to find that the IEBC could not conduct upcoming by-elections, could not stand because by-elections did not require any decisions to be made by the Commission of a policy nature. My Lord, the court, as rightly pointed out by, I believe, Justice Tuyot, was that that was not an issue here. The quorum of IEBC was not an issue in Isaiah Biwott. But what is key, my Lord, is that
what did the judge say? Did the judge pronounce herself on the issue of constitutionality?
The judge did speak to the issue of constitutionality.
At page?
Of the composition of the commission. It says, having considered the last page 185, having considered the petition, the Constitution and the law, and having regard to my findings and observations in the judgment, I find that the petition lacks merit and the order commends itself to me to dismiss it. When considering, in determining the constitutionality of the impugned provisions, the court says at paragraph 32, in determining the constitutionality of the impugned provisions, the rules of constitutional interpretation come into focus. providing the guidelines on the manner at paragraph 44 on page 184, this is what the court says. Having regard to the above decision, I do not find any inconsistency between the provision in paragraph 5 of the second schedule of the IEBC Act and Article 251 of the Constitution. Paragraph 5 required a quorum of 5.
What do you make of 43?
Paragraph 43.
Yes.
In the instance case, the petitioner prays for a declaration that the commission is illegal and unconstitutional for lack of quorum as a result of the resignations. The court finds that the alleged resignation was an issue that was neither here nor there and was not proved by any tangible evidence.
All right. So what's your bottom line, counsel, on that authority?
My bottom line is this, my lord, that the commission cannot say that that provision requiring a quorum of 5 does not exist today because of a declaration of unconstitutionality made by Justice Chacha Mwita on 6th of April 2018, when in fact the effect of that declaration was to nullify or void the provisions of the amendment and not what was amended. And that takes me to the effect or consequence of voidance. And I would like to cite...
Sorry, counsel, before you do that.
Yes, my lord.
It's clear from a reading of Isaiah Kibiwot
yes.
that the judge considered the decision of Judge Chacha Mwita in Katiba Institute,
yes.
right?
Yes.
And the bottom line in Isaiah Kibiwot was that even though there had been resignations, the IEBC could still conduct by-elections, etc.
Indeed, my lord, and I do not have an issue with that. And,
all right.
The reason...
That's fine, that's fine. So my question is, if IEBC, through no fault of its own, has 3 commissioners, and the court has held without appeal that they can conduct business of by-elections, why can they not conduct the business of verifying signatures?
For this reason, my lord, the comfort that the judge had in allowing the commission to conduct business of by-elections was specifically because by-elections, and she said so in her judgment, by-elections are not a matter that the IEBC has to make, requires decisions of the commission on. They are regulated by legislation. In this case, and it was conceded before my lords and my ladies, that there is no legislation governing the collection, verification, and presentation of signatures for a popular initiative. So that comfort that the judge had in allowing the by-elections, the IEBC to conduct the by-elections, was based on the presence of legislation governing that. But in this case, there is none, and that is an issue that has been conceded before this court.
Counsel, do I understand you to submit that the formulation of the administrative guidelines that eventually were used or was used to verify is a question of policy?
Indeed, my lord. I will therefore, because I feel like the bench is on the same page with me, I will not take too much of your time. I will just lead you to Cooley Thomas, Professor Cooley Thomas, his treatise on the constitutional limitations which rest upon the legislative power of the states of the American Union. And this is at volume 1 from pages 2 to 36. And I will just request, my lords, that you look at the consequence of declaration of unconstitutionality at page 36. And this is what it says. And what is true of an act void in toto is true also as to any part of an act which is found to be unconstitutional, and which consequently is to be regarded as having never at any time been possessed of any legal force.
Sorry, that is page
36 of volume 1.
Thank you.
And I believe, my Lord, that is why the judge and the parties were still adjudicating quorum at 5 in Isaiah Biwott long after the amendments had been declared unconstitutional by Judge Muita. I'll proceed, my Lord, to the role of the IEBC in verification of signatures of supporters of a popular initiative, and paragraphs 710 to 763 of the judgment deal with this, includes the findings and the declarations 11, 12, and 17.
Council, can I request that you start on that? You have 15 more minutes to go. At this juncture, we take a 20 minutes break. You come and start on that issue.
Absolutely, my Lord, I'm obliged.
Precisely after 20 minutes.
Much obliged.
Popular initiative, it is a presidential initiative. And to go back to the question that Your Lordship, the President of the Court of Appeal, asked me, whether once we donate once we donate sovereign power to you, do you still have individual rights? Like the President would want us to agree rather, yes. And like I said, you must clothe yourself of the executive authority, then become a citizen. I'll give you an example that happened with this same executive, Your Lordship. In 2014, our president was facing a personal case at The Hague. When he was leaving for that case, which was his personal matter to attend to, he did the right thing. And I believe, under the advice of Emeritus, AG then, Professor Gito Muigai, he handed over power to the Deputy President, appointed him as the acting president, went to The Hague as a citizen, was not received by the state there as a president, but as an individual. So if the president then wants to initiate such a process as a citizen, he must of all do exactly that. Announce to us that this is not the president doing this, it is me as a citizen. I see my time is running out. I have my colleagues to submit on a few issues. I submit that the appeals before you are not merited. The same should be dismissed. The court ought to uphold the judgment of the Superior Court. I'll invite my learned friend, Carol Gerono, to just address on a few issues. Thank you, my Lord.
Thank you, Mr. Mutuma. Please introduce yourself, and I hope you know you have like 10 minutes. Because we'll adjourn at 1:30.
My Lord, we had, my name is Miss Caroline Gerono. I appear alongside Mr. Mutuma and Professor Kindiki for the 19th, 20th, and 21st respondents.
With your permission, my Lord, could I seek a clarification? This court gave directives earlier on that each of the respondents will have 2 hours, and put a caveat that there should be no repetition. My Lord and ladies, this matter is so monumental. I want to plead with you, even as my colleague finishes her time, that you allow us to do our 2 hours. There will be 0 repetition, and I believe will be of help to the court. And so, my Lord, I did a directive so that you can guide us as we go for lunch.
Are you talking of, Professor Kindiki, you're talking of 2 hours over and above what has been taken by your other 2 colleagues?
No, my Lord, 2 hours cumulatively. I know we will be spending 1 hour by the time we go on recess, on adjournment. So I'm kindly requesting with tremendous humility if we could have the extra 1 hour after lunch.
1 more hour?
Yes, my Lord.
So do we then adjourn? Do we adjourn?
Ms. Cherono,
Yes, my Lord.
would you, in the remaining 9 minutes, have finished your bit?
No, my Lord. We had apportioned ourselves that I would do 30 minutes. So I would suggest to the court if we would adjourn for lunch, then we have 1 hour uninterrupted shared between me and between Professor Kindiki and myself.
Can we give Caroline Cherono like 15 minutes and Professor Kindiki for 30 minutes, a total of 45 minutes? We can adjourn now so that you are able to, put your thoughts better. We'll try to accommodate the request that you've made.
Sorry to come back on this, my Lord, but the appellants each had 2 uninterrupted hours, and they will also have a bite at the cherry because of the right to reply. It is only fair, my Lord, that you consider giving us, as a team, 2 hours, and how we share it, we can leave it to the internal mechanism.
Okay, then let us do this. Let us adjourn now, and when we come back, we will see what happens. We hear what you've said, Council. After 1 hour precisely.
This conference will now be recorded.
Now, before we start, we have looked at the record that is before us. That was in the High Court, and what is before us in form of these consolidated appeals, to try to see how to rationalize time to be fair and equal to, time allocation to all the parties. Now, there were several petitions in the High Court, 8 of them. 7 were consolidated, petition number E282. Then there was Kenya National Commission on Human Rights, and the 4 law professors who are joined as Amishai Kuria in petition number E282 of 2020. Kituo cha Sheria was also joined as interested party in petition number E400 of 2020. So in 400 of 2020, the players were Third Way Alliance, Neruru Aweru, and Angela Mwikali. Mr. Mutuma, that is where you are.
Yes, my lord.
And Professor Kindiki, you are also in that, you are leading that team. Who is representing Morara Omoke? Morara Omoke was in a petition number E416 of 2020. Dr. Thiankolu. Okay. Led by Mr. Okay, Nyamwega. Okay. Nyamwega, yes. Yes. Then we have Jasas Juma and Isaac Ogola in 402 of 2020. Who appears for them? Okay. And E401 of 2020, there is Hope 254 Hope. Who appears for 254 Hope? Dr. Ebos. Yes. Dr. Eboso, you have the cross appeal. Okay. Then there is E426 of 2020, Isaac Oluchier. You're appearing for yourself. Okay. And there was petition number 2 of 2021, which was initially in Mombasa, Muhuri, mostly for human rights. Who is appearing for Muhuri? Sorry? Kituku. Okay. And that is Dudley? You appear for who? Dr. Jack Wemali. Was he a petitioner in the High Court? Sorry? He was amicus. So amicus, we have told them to put in their submissions, and I believe they have. Then there was E397 of 2020, where there was David D, Gerald Sei, James Gondi, Wanjiru Gekonyo, and Carl Angelei. I believe Mr. Havi and team, you appear for them. And you've already done your case. Now, in the morning, sorry? Yes. Just check whether the microphone is on.
May it please, my lords, Martha Karua with Muthoni Nyuguto for 3 Amishi. That is Jack. Let me read from the whatever. Dr. Duncan Ojwang, Linda Musumba, and Dr. Ambani. And my lord, we are not here as Amishi. We were Amishi in the Superior Court, in the High Court. But here we have been brought in as respondents by the appellants, and we have responded as respondents. So we are sitting here expecting to get our time, and a lot of allegations have been made against the Amishi and their submissions in the High Court. So we are sitting here expecting to get time to respond. And we have already put in our submissions as respondents because we were dragged here as respondents.
Even when we were Amishai?
We would have come as such, but we were brought as respondents by the appellants.
By the appellants.
Some of whom now question how we are here after bringing us. So we are here ready to argue our case.
Okay, and you would require how long?
Opportunity, the respective appellants against which specific orders were made to make their case, to also push back that case. If we are able to finish our case within an hour, 1.5 hours, or less than the 2 hours, we will cede our time back to the court for good order, and we will endeavor to do that. Let me make it, we will be deliberate about trying to ensure that we save as much as possible to cede it back to court. But let us reserve our 2 hours.
Right, we'll come back to you. Thank you.
My Lord.
Dr. Eboso. Yes.
I believe I will require at most 1.5 hours to conclude my submissions.
President, with your permission, counsel, please, and parties, of course you're entitled to your pound of flesh, but we on this side don't have that much to give you each your pound of flesh. You can imagine how much the court has suffered if we have been here, 7 of us, for this entire week. So we plead with you, really. You have put in submissions, very, very elaborate submissions. If there's a way you can, I'm sure, counsel here, normally in usual cases, you do these things, we give you 5 minutes, 10 minutes, and you're done. This is important, all right, but can you at least try? You can cut that by half. I'm sure it's possible.
My Lord, with your kind permission.
My
name is Busiaga.
Busiaga?
Yes, Busiaga. I'm appearing with Kevin Doho Masharia for the Kenya National Union of Nurses. Really, our position has been covered largely by both sides. And if we could be accommodated for 30 minutes, between the 2 of us will have finished.
All right.
We will not go to rehearse what eminent persons have already.
All right, thank you, Mr. Busiaga. And just a minute, Isaac Oluchier. You need about 1 hour. We're just getting the indications. Ms. Kituku, if you can hear us, you appear from Muhuri. Somebody says she's appearing virtually. Okay.
My Lord, with your kind permission, my name is John Mwariri from Kituo cha Sheria. I would wish to echo the request by Honorable Karua that we'll be requesting for 40 minutes. We are led by Dr. Haminwa, both for Kituo cha Sheria and Kenya Human Rights Commission. So our humble request is that you give us 40 minutes for our submissions. That is both for Kituo cha Sheria and Kenya Human Rights Commission.
My lords, my ladies, my name is Wanjiku. I'm just asking probably for clarification. Because when we were granted our opportunity to make submissions before you, we were at least constrained of time, just like, and we were respondents. What happens to the equality of arms? Shall we be granted an opportunity then to do a rejoin of their submissions so that then there can be equality of arms? They are all respondents deserving equal treatment.
My Lord, with your kind permission, my name is Awele. I appear alongside Senior Counsel Otiende Amolo and James Orengo. I'd like to just pitch in from where my learned friend has left. My learned senior, Martha Karua, has intimated that they were dragged to this court as respondents. Speaking on behalf of the second and third appellants, we sued, or rather we filed this appeal and cited the amicus as amici. And even if they were cited as respondents, it was not by choice. It was on compliance with procedural guidelines of this court. The Court of Appeal rules provide that any person who is served with a notice of appeal shall file their notice of address of service as respondents. And so the mere characterization of them as respondents cannot give them the right to then come and substantively take an adversarial position from that which they took at the High Court. We are asking, ordinarily we would not be objecting to amici making presentations. But if the court is going to restrain one amici, or one amicus rather, from making oral submissions before it, I think it is only fair that the court applies the same standard on all amici, because they did not make any substantive pleadings at the High Court or prayers that would warrant them now taking an adversarial position in this appeal. And so I think, even just for the management of time, I think it would be in order if the court were to stamp its authority. Their submissions are quite lengthy. We do not agree with the adversarial position they've taken, but we'll deal with them in our submissions. But for purposes of equality of arms, let all amici be treated equally. Most obliged.
If the court allows me to respond to Mr.
Just senior counsel, before you respond, just hold on. Is there any other party that had filed a petition and I have not called them? Respondent. Is there a respondent who had filed a petition? All right, because I say there were 8 and that were consolidated. Okay. Now, senior counsel, what do you say? I have basically taken time indications. We haven't allocated time. We are going to make a decision because we must manage time in such a way that we finalize this matter by tomorrow 4:30.
Yeah, I will not take the court's time. I just want to draw the court's attention that in the Memorandum of Appeal, Volume 1 by the AG, ground of appeal number 6 is devoted to the amicus, and in fact we are being referred to as purported amicus. So it's really adversarial, and it is in that capacity we have responded.
Okay, we may give you some time to respond, but it will not be the 1.5 hours that you're talking about. We will see how much time to give you, because we agree that there is a specific allegation made about or against your client as amici. Now, just you all heard what my brother Justice Kiage said. We will have to accommodate one another insofar as this time allotment is concerned. The parties who wanted to file submissions have put in very good submissions, all of you. And so if we were to allocate at most 1 hour or so, we think it will be possible to accommodate the main parties and amici Other than those, the ones who say were specifically referred to, we'll give you much shorter time to respond to those issues. And when you get to the podium, please just highlight your submissions. Now, Caroline Cherono, can you take the podium?
Thank you, my lord.
Let me have your submissions, please. Please carry on.
For purposes of record, my name is Caroline Gerono. I appear for the 19th, 20th, and 21st respondents. My lord, my learned friend, Mr. Mutuma, has taken the court through the process termed popular initiative as it ought to be, and how the appellants, or how the impugned Constitution of Kenya Amendments Bill 2020 was processed. I'll take the court, or my submission rather, is on the part of public participation with respect to the Constitution of Kenya Amendments Bill 2020. My lord and my ladies, I will begin by drawing the court's attention to our Bundle of Authorities, Volume 2, that is dated 23rd of June 2021, at page 558, that is Raila Odinga, sorry, Your Honor, just a minute. That is paragraph, page 668, Raila Amolo Odinga in another versus IEBC and two others. The learned judges of the Supreme Court, while nullifying the presidential elections of 2017,
yes,
stated that while relying on authorities as stated in that authority, that election is a process. It is not a one-day event. I will not belabor the court because we have filed the authorities and the court can revisit later. And the appellants have indeed confirmed to this honorable court that referendum is an election process, is an equally a process as opposed to an event. And because it is a process, then there are parameters that have to be complied with. We submit, my lords and my ladies, that even if the promoters of the 2020 Amendments Bill had rightfully started the process, I'm avoiding the term initiated, in consideration of Article 257(1) of the Constitution, then there was complete violation of Article 10 and Article 33 of the Constitution. My lords and my ladies, I draw the attention of the court to our authority found in our Bundle of Authorities, Volume 2, at page 558, that is Republic versus IEBC, Expert National Super Alliance, NASA, and 6 others. The court, as paragraph 160 in that judgment, held that the people of Kenya did not intend that these provisions be merely suggestions, superfluous or ornamental. They did not intend to include these provisions as lofty aspirations. Kenyans intended that the said provisions should have substantive bite and that they will be enforced and implemented. My lords and my ladies, we demonstrated in the High Court chronologically how the promoters of the 2020 Amendment Bill abrogated the provisions of Article 10. And we submit here today that they have not even attempted to tell the court if at all they did comply. My lords and my ladies, Learned Senior Lucy Kambuni told the court that a promoter would appeal to people whom they deem that they would be moved or convinced by the proposal in the process of collecting signatures. That means there is a possibility that a promoter of an amendment would go to a particular place, call upon his or her friends, or even pay them, whichever manner, collect the signatures, it doesn't matter, leaving out all the other counties, leaving out the common Wananchi, who is in Kakuma, who is in Homa Bay, who is in Tana River. The promoters have told this court, or the appellants rather, have told this court that a popular initiative only becomes so at the point of signature collection. My learned friend, Mr. Mutuma, has demonstrated to this court that changes to a constitution by amendment does not begin at the collection of signatures. It begins from the enactment stage. We demonstrate to this court that the bill, the Constitution of Kenya Amendment Bill 2020, I would call the impugned bill, was not prepared in such a manner. It does not comply with Article 10 of the Constitution. There was no public participation. And I demonstrate this way, my lords and my ladies, that the motive of the promoters, as it has been submitted, that it is the executive, the motive, the intention was not presented to the people of Kenya. The first Gazette notice was all about policy issues. The second Gazette notice number 264, which is dated 10th January 2020, includes statutory changes. The recommendation, the terms of reference include statutory changes and constitutional changes. The appellants have not belabored themselves to demonstrate to this court that indeed, when the steering committee went round as they purport to have done, did they present to the people of Kenya that we want to change the constitution? What do you say about this article? What do you say about this clause? Were the people of Kenya informed? Our answer is no. The Kenyan people were not made known of the intentions of the executive as it has been demonstrated. If the court so finds that indeed the executive is allowed or permitted by law to carry out changes or amendment to the Constitution under Article 257, did they make it known to the people of Kenya that there is an intention to change the Constitution? I will refer the court, and I see my time is running, to what my learned senior has referred to, the supporting affidavit of Miruru Waweru that is found in Volume 4 of Record of Appeal of the Attorney General. The forward by the BBI Steering Committee to the President. They told the court that the Steering Committee held 93 stakeholder meetings. Where were they held? KICC, Laiko Regency, and the offices in Nairobi. My lords and my ladies, this country comprises of people living in 47 counties. The stakeholder meetings were carried out purely in Nairobi. At the point of effecting service upon then the first and second respondents, that is BBI Steering Committee and the BBI National Secretariat, we had a challenge. We had to serve their advocate. That means the officers were not even known to us. What about a common Mwananchi? On that account alone, my Lord, I pray that, or I submit that, the High Court was right in holding that there was no proper public participation. I refer the court to the authorities that we have cited, and more specifically, the county government of Kiambu versus Robert Gakuru. It is found in volume 1, sorry. Volume 1 of our bundle of authorities at page 125. And your ladyship, Honorable Lady Justice Nambuye, together with the team, upheld the judgment of Honorable Justice Odunga in that there was no public participation in the process of enacting Kiambu Finance Act. And the entire process was nullified on account of lack of public participation. And the courts, both in the Superior Court and in the Appellate Court in this case, made reference to the famous Doctors for Life case, which we have relied on in our written submissions, both at the High Court and before this Honorable Court, and it is in our bundle of authorities, volume 1, as well as in the judgment of the Superior Court, on the emphasis on public participation. That when there is no public participation, any legislation that suffices is invalid by virtue of lack of public participation. My lords and my ladies, I draw your attention to paragraph 22 of that authority, where the court, relying on Doctors for Life case, stated that the bottom line is that public participation must include and be seen to include the dissemination of information, invitation to participation in the process, and consultation on legislation. We submit that this was not adhered to. My lords and my ladies,
yes.
Sorry, my lord. My lords and my ladies, if we get now to the collection of 1 million signatures, as per Article 157(4) of the Constitution, we have laid our basis that at the point of enactment, at the point of formulation of the amendment, the questions to be posed at the referendum in the event that it would end in a referendum. Wanjiku was not involved. Wanjiku was never invited. It was an executive affair. At the point of signature collection, were the people of Kenya involved? We submit that they were not. And the appellants have told this court in their own admission that the role of Wanjiku is preserved for a referendum. That public participation, it was premature to carry out public participation before the referendum is rolled out. We submit that in a situation, in a scenario, my lords and my ladies, where when the bill lands at the president, and the president deems fit that none of the suggested amendments fall under Article 255(1). And so it does not need to go to a referendum. At what point will the views of the Kenyans be absorbed or be incorporated if at the initial stages they were not incorporated? Because prior to the bill getting to the county assemblies, prior to the bill getting to parliament, there is still a window for the Kenyans to make their suggestions as to whether they agree or not on certain elements, on certain suggestions. But once IEBC presents that bill or those referendum questions, suggestions to the county assemblies, as it is, any public participation undertaken thereafter is inconsequential. So we submit that by closing that chapter and telling the people of Kenya that you wait, referendum is on the way, that is when you will express your views. That is an absolute violation of Article 1 on the sovereignty of the people of Kenya. My lords and my ladies, see my time is up. But I would want to peg the question to the IEBC. IEBC have submitted to this court that their hands are tied. Their duty, their obligation was to only verify, just confirm if the initiative is supported by 1 million registered voters. Article 1888, Sub-Article 4G of the Constitution gives IEBC the mandate to carry out voter education. What does voter education mean? In election, in a general election, for example, IEBC would conduct civic education to sensitize Kenyans on how to vote, the colors that they are going to use, a kind of demo on how the actual election would be. In this context, why would IEBC give a template to the promoters on how to collect signatures and fail to dispense its constitutional duty to tell the registered voters of this country that, look here, something is coming, and this thing is going to affect your day-to-day lives, because if it is approved, it becomes part and parcel of the Constitution, and it will affect every other Kenyan. IEBC would have carried out voter education, tell the people of Kenya how to append their signatures and what they are appending their signatures to. That way, there would have been public participation. In this context, it did not happen. We are told that IEBC, having received so many million signatures, verified it as they call it, and cast it on their website. My lords and my ladies, it baffles me that the Attorney General says that in the event, sorry to digress, but I'll come back to it. In the event that this bill goes for a referendum and that the judges having held that there should be multiple questions as opposed to binary questions, then at paragraph 150 of their submissions, the Attorney General's submissions, that it would disenfranchise Kenyans. That this country consists of 7.8 million adults, illiterate adults. Why would it be that it would disenfranchise Kenyans at referendum and not now when they are endorsing a document that they have not read? We submit that there was no public participation from the initial stage to the collection of signatures, and even to the county assembly level, where we gave an example of Siaya County, we gave an example of, there is a case which we have cited, that is Tana River case. I will not refer to it because my time is up, where the court nullified the process, and I pray that this court will have a look at that case and how maybe going forward on the jurisprudence of that case.
What did you call it? Siaya case?
Sorry?
You say it's Tana River County.
Yes, it's a Tana River County case. You will forgive me because my time is up.
No, if it's in your bundle, we'll look at it.
Yes, it's in our bundle of authorities. I submit, therefore, my lords and my ladies, that on the account of violation of Article 10 and Article 33 of the Constitution, that the court rightfully made its findings and that this honorable court so upholds. I rest my case.
Just before you go,
yes.
The Siaya County you just told us about.
Sorry?
Siaya County,
yes,
and Tana River.
Yes.
Was this presented as evidence before the Superior Court?
Yes, my lord, it was.
There was evidence before the Superior Court?
Yes, it was. We had made an affidavit, in fact, an application that gave us a ruling that stopped the president from assenting or from doing anything whatsoever prior to the determination of the petitions as a result of the actions of Siaya County, County Assembly.
Thank you very much.
Thank you, my lords and my ladies.
Thank you very much, Counsel. Who is next?
It is that decision that the appellants now ask this honorable court to overturn, citing an array of grounds. My lords, my ladies, we humbly submit that the consolidated appeals be dismissed in their entirety with costs to the respondents, and the decision of the Superior Court be upheld and affirmed for the grounds that we submit herein below. My lords, my ladies, all the appellants view that the so-called Building Bridges initiative was a popular initiative. With tremendous respect, we strongly disagree. Instead, we agree with the Superior Court that this was not a popular initiative. It was rather it was a presidential initiative or executive initiative, which is not provided for in our Constitution, and the attempt subsequently by the initiative's promoters to rope in the people at the tail end of the process to sanitize their illegal and unconstitutional venture must spectacularly fall on the facts and the evidence. On the issue of the character of a popular initiative, we make two arguments. The first is that we agree with the Superior Court that this illegal process to amend the Constitution of Kenya was initiated by the President of the Republic of Kenya in its official rather than private capacity. We say so for these reasons. One, the fingerprints and footprints of the President of the Republic are strewn and splattered all over this heinous affront on the Constitution of our country. My lords, my ladies, secondly, the President created a task force, after which he created a steering committee to implement the recommendations of that task force. And the mandate of that steering committee was clearly stated in paragraph B to include making or proposing legal, administrative, and even constitutional changes. Thirdly, on that point, is that the President established both the task force and the steering committee via the Kenya Gazette. It is our submission, my lords, my ladies, that the Kenya Gazette is not a newsletter, it's not a newspaper, it is not a pamphlet, nor is it a private publication. It is the official publication of the government of the Republic of Kenya, and for that reason, the President, in appointing these institutions, was acting in official capacity, which is our first argument. Further, to cement that argument, the steering committee so established generated a report, and attached to that report was a bill to amend the Constitution, which bill is the subject matter of this litigation. And it is a bill upon which the signatures, which are in contention here, were collected. The fingerprints of the President and his footprints are also evidenced by this, that the submission of the task force report to the President, the submission of the steering committee report to the President, the launch of the collection of signatures exercise, and all other events associated with this ill-fated exercise or process were presided over by the President of the Republic of Kenya using state machinery, and none of these meetings or events took place in anybody's private home. My lords and my ladies, it is our further submission that the reports of the task force on the same point and the report of the steering committee were addressed officially, and I quote, to, open quote, His Excellency, the President of the Republic of Kenya and Commander-in-Chief of the Defense Forces, the Honorable Uhuru Kenyatta, comma, CGH, end of quote. Further, it is not controverted that the collection of signatures for this cause was aided to some extent by public officials, chiefs, and other public officials within the executive arm of the executive, which the President presides over. At no point in the whole exercise did the President relinquish his tools of official functions, as was ably cited by my learned friend, Mr. Mutuma. There is a precedent in 2014 during the International Criminal Court cases, and I am privileged to have been one of the defense counsel in the Kenyan cases at the International Criminal Court. And when it came to the hearing of that court and the initial appearance, the President of the country downed the tools of power openly and publicly and signed a deed in which he appointed his deputy for approximately 60 hours or thereabout to act as President of the country so that he could attend to what he termed a private and personal matter as a private citizen, Mr. Uhuru Muigai Kenyatta. My lords and my ladies, on the second argument on that point, we submit the President of the Republic of Kenya has no right to initiate a popular initiative. Why? Because this avenue of popular initiative is reserved for private citizens, including civil society, and is not available to state officers or state organs. The learned judges in the Superior Court took time to explain that the historical context of Article 257 on popular initiative, according to the Bomas report, was the history, the checkered history of Kenya with constitutional amendments. And therefore, it was clear that citizens wanted an avenue where they can amend the constitution and force government to legislate things that they think government through the organs of state does not wish or is not ready to legislate. How then can the same government, which is supposed to be compelled to legislate by the people through a popular initiative, be the same government using that avenue? And therefore, we agree with the learned judges of the Superior Court that there were other avenues available to the head of state and the president to initiate whatever amendments he wanted to do. First, under Article 132 of the Constitution, the cabinet may make proposals to, for legislative proposals, the cabinet can do that. Also, the Attorney General under Article 156 of the Constitution normally aids the President in bringing government legislation. And under this Constitution particularly, the office of the Leader of Majority in the National Assembly and the Leader of Majority in the Senate is actually the avenue through which government bills and legislation proposals are channeled. And I speak that with some little authority by virtue of my previous background outside the premises of what we are dealing with today. That therefore this was the wrong avenue for the president to use, and he had other avenues to use. Secondly, on the same point, the second reason why we say that this route is not available to the President of the Republic of Kenya is because, as it was found in the Superior Court, that there was no evidence tabled to provide that the President came and failed. On the second thematic area of public participation, which my learned colleague Gerono has submitted, I just want to add the following comments. First, I was somewhat surprised when learned senior counsel Otiende Amolo yesterday, or is it the day before, submitted before this court, tried to demonstrate how it is it's impossible for all the steps of public participation identified by the learned judges in the Superior Court for public participation if we are to allow Wanjiku to be the one to drive the popular initiative. We disagree with that view because, and I heard senior counsel Otiende Amolo exemplify and ask the courts to reflect on whether, for example, Wanjiku can have the bill published, I don't know, in the national languages, the national language, which is Kiswahili, the official languages, which is English and Kiswahili, the vernacular or indigenous languages, and so forth and so on. And he said if we submit Wanjiku to this kind of procedures, it will not have been possible, and I hope I'm not misquoting learned senior counsel. Our view is that this demand, this 10-step process demand, was not the invention of the learned judges in the Superior Court. It is a dictate, a requirement of the Constitution in Article 7 of the Constitution, which the learned judges relied on, which calls on state organs and state processes to, for example, use the the languages, and even try to promote indigenous languages and the use even of Kenya Sign Language and Braille where possible. And when it comes to the technical side around Braille and Kenya Sign Language, the Constitution is considerate and uses such terms as promote as opposed to demanding outrightly that that must be done. And therefore, on this public participation, it is a demand of the Constitution. Secondly, on the same theme, it is our submission that both the popular initiative and the parliamentary initiative must therefore adhere to what the learned judges provided for the 10 steps of public participation. There was very little public participation in the processes that were taken up to this point before this litigation arose. For example, the example was given of Siaya, which passed the bill upon receipt. Siaya, in their wisdom, the assembly in Siaya County, in their wisdom, decided to pass this bill within 24 hours. I don't know whether they did the public participation at midnight or at 3 a.m. and what methods they applied. Within a day or two, they had passed it. Tana River attempted to do the same, but the county assembly of Tana River was stopped on their tracks, and their action, which had already taken place, was nullified by Chepunyi J, sitting in Garsen, where he said that you cannot submit a bill, a process of enacting such a fundamental bill amending the Constitution and process it in microwave time. In fact, that is the term. You'll see that when you retire in the authority which my learned colleague Gerono cited. It's called Abe, like Abe Shinzo, Abe Brere. Abe Brere, I hope I'm not mispronouncing, Abe Brere versus the Speaker of the County Assembly of Tana River and 2 others. And the judge said, don't even take what you have passed to Senate or even National Assembly. And the thing died. But because the promoters had already had their kill, they had enough majority, so they proceeded, notwithstanding that they didn't have Tana River County Assembly on board. And my Lord, why are we emphasizing this? It's because there's a reason why the Constitution demands that the bill be submitted in Article 257, the bill be submitted to the county assemblies for 90 days. The county assemblies have 90 days to process the bill. There's a reason, and that reason is public participation, among others. I say so because I had also the submissions yesterday by learned counsel, Mr. Gumbo, who told this court that in a different issue of signature verification, the regulations demanded that IBC should take 14 days, but in the wisdom of IBC, they decided to shorten that process to 5 days, which included a Sunday, which is normally not computed in terms of time. And therefore making the whole issue of statutory timelines a laughing stock. I am afraid to submit that, unfortunately, for such an important institution of the state like IBC to be dragged into this business of hop, step, and jump, similar to the legend in the Simon Makonde story, where in 7 days, the politicians involved in this process actually marshaled and stampeded millions of signatures in 7 days, like Simon Makonde, who was born on Monday, and something happened on Tuesday. I think he was named. He got married on Wednesday. On Thursday, he fell ill in water.
I'm not sure it was the same week, but carry on.
Thank you, my Lord. My Lords, therefore, we submit that public participation must start earlier and continue throughout the process, and it must involve the people. We also submit that the appellant's erroneous view that those who signed to support this bill, the 1 million that signed, are presumed to have understood the content of the bill, which is the gravamen of the appeal, part of the gravamen of the appeal by the Honorable Attorney General. This submission cannot stand because, my lords and my ladies, that public participation cannot be presumed. The authorities that we have filed, the Robert Gakuro versus County Government of Kiambu, the Doctors of Life case, and so many other cases, even outside this country, we filed them in our documents. These authorities say that public participation is both qualitative and quantitative. It cannot even be presumed, it has to be real. I think in Doctors of Life, the judges said it has to be real, not illusionary or thereabouts. Therefore, when you see county assemblies, almost all of them, the entire country, passing such a monumental, or rather passing or endorsing such a monumental bill, which is amending not less than 74 parts of our constitution in a swap, making the regime of...
Counsel, sorry. Was that part of the evidence before the Superior Court? The statement you make? Is that
which one in particular?
That the county assemblies passed it in speed light. Was it a matter of evidence before the Superior Court?
You know, my lord, I don't want to lie to the court. I came on board this matter at this level, and therefore I don't want to take responsibility for that, and I'm relying on our written submissions. So maybe that's something that Mr. Mituma can clarify. Thank you.
Ms. Counsel, Prof, just a point was raised about who bears the burden. And if I heard the appellant correctly, they seem to say that consistent with the requirements of the Evidence Act, he that alleges must prove, and they said that insofar as your clients were alleging that there was no public participation, it fell upon you to prove that. What's your comment on that?
Absolutely, I agree. That is the position of the law. But in context of this matter, once, first of all, there is the standard of proof, which in this kind of a matter, which are not entirely civil matters, they are sui generis proceedings, but they are not criminal matters. So the standard is normally of a lesser, it's on a balance of probability. And I think at the Superior Court level, the issue of public participation, lack of it, was proved to that level, and that's why the judges took a bit of time to agree largely with the appellants, with the petitioners' positions and evidence. I am referred by Mr. Mutuma to page 1663 of our volume 4 of the Record of Appeal. Volume 4 of the Record of Appeal, page 1663, where the issue asked by my Lord, Mr. Justice Tuyot, is answered in the affirmative, particularly the affidavit of Miruru Waweru, paragraph 8, how the county assemblies passed this bill, considered this bill in a lot of haste. Because of my time, my lords and my ladies, we also note that the MCAs, which is a fact, were given a car grant, but that's neither here nor there. That does not mean that they didn't have to follow the Constitution and the timelines given by the Constitution. Our submission is that the timelines given by the Constitution or statute are deliberate. They cannot be played about with or hurry them up, especially when they concern such serious and grave amendments.
The period was reduced from 90 days to how many?
Within 30 days, I think the entire country, except one or two, like in Meru took a little more time, maybe about 40, 45 days, I'm not sure. But the rest of the county assemblies consider this bill in less than 30 days, within 30 days. And that is in our affidavit.
In your view, what was supposed to happen after it's committed to the county assemblies within that 90 days?
Qualitative and quantitative public participation.
Through the county?
In the county, by the county assembly, which of course includes, if you look at it from quantitative and qualitative approaches, that includes time. And for me, they should have taken most of the 90 days to comply with the 90-day deadline, maybe 60 days, 70, 75, 80, or even 90 days. My lords, my ladies, allow me to rush to something which was submitted here by the Council, Senior Counsel Atiende Amolo, on the JLAC report of Parliament, because he made some remarks that is not binding. I just want to say that this report is a public document. We also produced it as a result of the directives of this court to adduce additional evidence. We want to simply submit that this report of the Joint Committee of the National Assembly and Senate, the Committee on Legal Justice and Legal Affairs, this report was tabled in the two houses of Parliament, and once tabled, it became the property of the two houses. And it is not true to argue that once it was tabled, because it was not voted on, then it has no evidentiary value. We believe and we submit that both that report and the proceedings, the answered proceedings of the Senate, which reflect the true records, are important evidence, which demonstrates one thing, my lords and my ladies. What the two sets of documents demonstrate is that within the proceedings in Parliament, including the Justice and Legal Committees of both houses, it was clear from the report and from the Hansard proceedings that the finding of the report was that many provisions in the bill, the proposed amendment bill, were unconstitutional. But surprisingly went ahead and said, but we recommend it be enacted. For example, the issue of Schedule 2 to the report, the JLAC report, which consisted the list of, the issue of additional constituencies. The committee found that there were legal issues that made that with the law, and recommended actually there was a recommendation even of severely that Schedule 2 from the report. But we want to leave it at that and say that it is not true that these proceedings and these reports are of no probative value. We submit, my lord and my ladies, I also listened with significant surprise also learned counsel, my senior Mohamed Nyauga, told this court something about the immunity of the head of state, and I thought I should just, in a snippet, submit that, the old idea of absolute immunity of heads of state has been abandoned in all the constitutions of the world and under international law. It's an archaic legal doctrine, originally from international law, but which was not infused in national constitutions. But since, especially 1990, the landmark international case of which this is not the Pinochet case. The Augusto Pinochet was a former head of state in Chile, and he did what he did for many years and fled. He went to Europe. He was arrested, extradited, returned back to Chile, and in that case, because that case took place in the UK, the judges made it very clear, the House, that it is not the job description of a president to torture and kill people. So immunity cannot be absolute, because those were their charges against Pinochet. And from there, that doctrine is old, and the court should not give any effect to an argument that immunity of the president is immune. The Constitution in itself, the court really guided on that area, is very clear. Does not include commission of international crimes, does not include when the person leaves office, it does not include actions which are not functional. They are not related to the function of the head of state. My lords, my ladies, allow me to say a few things. I know I have 12 minutes on the basic structure. And I'm sorry, my Lord Justice Kiage, I have to do this because the same thing can be attacked from a million sides, and I won't repeat. I hope I won't repeat anything about basic structure. And for me, what arises from all this discussion about basic structure, eternity clauses, and so forth and so on, is whether, my lords and my ladies, there is a hierarchy of norms in our Constitution. That is the question. Is there a hierarchy of norms? We submit that there is a hierarchy of norms. Why? We can even start with Article 255 itself. 255 is saying, my lords and my ladies, 255(1) is saying you can amend the Constitution through Parliament under 256 or through the people under 256. But there are 10 or so things you cannot, whichever method you're using, you must go back to the people. Paragraph A to J of Article 255(1). That's already a hierarchy. It means you can touch the rest, but you can't touch this one. Second example, in the interest of time. Learned Senior Counsel Professor Githu Muigai, who I consider to be my complete hero on this topic of constitutional amendments by virtue of his PhD thesis, submitted before this court yesterday that the Independence Constitution had some entrenched, some superior values, but they were removed. But they were returned again at Bomas, and they found their way in the 2010 Constitution. So what council, the Appellants Council have been telling us is that, oh, the court never said what are these entrenched provisions or basic structure or eternity clauses. And without going into the tautology and phraseology, there is, in my humble view, there is a hierarchy of norms. I'll give you an example, my lords, and some of these questions were even raised from the court, to my great pleasure and satisfaction. If you want to change the Constitution of Kenya and remove the provision that says that Kenya is a democracy, I think it's in Article 4.2 or thereabout. Kenya is a democratic state, multi-party democracy. You want to replace that and say, for argument's sake, that Kenya is a constitutional monarchy. Is that really the same as if you want to change the Constitution, Article paragraph 249 on independent commissions, which says that the number of commissioners is between 3 and 11 and 9. Suppose you want to say you lift from 3 to 5 and lift the other side, the ceiling side, from 9 to 11. Will amending that amendment be the same as an amendment that is trying to convert Kenya from a democracy, a multi-party democracy, to a constitutional monarchy? Are they the same? They are not, in our humble view. Second example, if you want to change the territory of Kenya in Article 5 of the Constitution, the territory of Kenya is defined. What the territory of Kenya, what constitutes the territory of Kenya? It is that territory in place on effective date of the Constitution, and then split into then the counties. So the territory of Kenya is defined in terms of the whole and the subnational units, the counties. You want to change that and sever some part of Kenya and donate as it used to happen in the old days of international law. If a sovereign was happy with a sovereign of another country, they could donate a part of their land or their space to a neighboring friendly country. That is how Alaska came to be part of United States of America. If you look at the geography of North America, Alaska is somewhere between Canada and United States. Somewhere in between there. Sorry, the other way around. Alaska is beyond Canada. It's after Canada. So you have United States of America, you have Canada, and then you have Alaska. Why? Because it was, it was a gift. It was sold to the American president, leader, by the leader of USSR. It was part of USSR across the ocean. So it was sold for $3 million, some 300 or 200 years ago, and so forth and so on. Therefore, we submit with great respect that there's a hierarchy of norms. All norms are not equal. But we secondly submit that the judges of the Superior Court did not say you cannot touch these superior entrenched basic foundational provisions. They didn't say so. Instead, they said you can change, but not this way, not in the ordinary way. You must go back to the people and the people themselves. That brings me to my last submission, because I have 5 minutes, which I will spend now on my last submission on this area, which was introduced, again, to my great satisfaction and interest, because of my scholarly background, by learned senior counsel James Orengo, on the place of the supremacy of the people, because it's relevant to this. We submit as follows, and I agree with senior counsel James Orengo on this. Elsewhere we've argued this issue, and we are concurrent about the supremacy and the elevated status of an organ which is not really considered as a constitutional organ, but if you look at it carefully, there is an organ, a constitutional organ called the people. But what I disagree with tremendous respect to my learned senior counsel Orengo is characterization that this organ, in quote, called the people, must exercise their sovereignty within the Constitution. For the following reason, my lords and my ladies. If you look at the preamble of the Constitution, the people are the creator of the Constitution. So the Constitution cannot be superior to the creator. It's a creature of the people. Look at the preamble. I know there's a provision in one of the foundational principles, one of the basic structure principles, I think there's 2 or 3 there, which says, Article 2 or 3 of the Constitution talks about that the supremacy of the Constitution. It's Article 2. It's Article 2. Yeah? Supremacy of the Constitution, how this Constitution is supreme. But that supremacy ends where the power of the people starts. And that's why the Constitution in the preamble is saying, we the people. Let me just read that. I have 3 minutes. Very important.
Professor, as you do that,
yes,
I understood Senior Counsel Orengo to say that whereas indeed the people are sovereign, the Constitution in express terms says that they shall exercise their sovereignty only in accordance with the Constitution. Those are plain words, black and white.
Which I disagree with, my lord, with great respect.
No, sorry. Are you disagreeing with the words that's how they are written, or you're agreeing with the statement?
I am disagreeing with the notion that the people are bound by their creature the creator is bound by the product of their creation to do certain things in a certain way.
But can we first of all agree, does the Constitution say that they can only exercise their sovereignty in accordance with the Constitution? So we agree, first of all, we move from text to whether now we agree with the text.
I agree, my lord.
All right, carry on.
Thank you. The reason I argue this is because, unlike my learned senior, James Orengo, who argued that the Constitution is supreme and even the people therefore must act within it, for the reason I have given, that the people are the creator and the Constitution is the creature, the people can even decide to abolish the entire structure here themselves. The people can decide that. And therefore my argument is, yes, the Constitution is supreme, especially the elevated clauses. The Constitution is supreme. But above the Constitution is the people. And I dare say, I dare submit, above the people is only Almighty God and the blue sky. If you look at the preamble to the Constitution, it says, and I quote as I end my submission, "We, the people of Kenya," the opening words. That should even send if you're interpreting the Constitution, that should tell you the first sentence, the first phrase in this Constitution, "We the people," the Creator. We the people of Kenya, acknowledging the supremacy of the Almighty God. The only supremacy above the people is that of God Almighty. It's in our Constitution. I am not bringing theology here. It's in the Constitution made by the people of Kenya. Therefore, without wasting time, my lords, I believe that above the Constitution is the people. And above the people is only the Almighty God and perhaps the blue sky, because it's also hovering over us as the people. For those reasons, therefore, my lords and my ladies, with tremendous respect, I urge this court to dismiss all the consolidated appeals, the appeals as consolidated in their entirety with cost to the respondents. I also urge this court to find that apparently what we are talking about here was a botched attempt to overthrow the people and their constitution at the same time. Luckily, by the grace of the Almighty, the judiciary, through the Superior Court, came and, in my view, rightfully interpreted this Constitution and declared that botched attempt to overthrow the people and their constitution a nullity. Unless there are questions from the bench, I will request my lord and my ladies that I be permitted by the court to resume my seat.
I guess there is none. Thank you very much, Professor Kindiki. Yes, you may have raised most of the issues, but they have been covered substantively.
Your Lordship, the challenge is that the perspectives that we have towards the issues is a little different from our colleagues.
Can you try to work within that? We will see how far you will have gone. Please try to work with that.
Number 3, we file written submissions. I believe that you have our latest copy that is more clear. The assistants were informed. Number 4, we file a list and bundle of authorities dated 23rd June 20.
They have been given to us, so please
Yes.
commence. We have them here as a bundle, so please
And
carry on.
we also filed a digest of authorities, supplementary record, and an affidavit.
Put on the time.
I will commence. I will deal with public participation and IEBC quorum. My colleague, Dr. Thiangolu, will deal with the political question and the basic structure. Mr. Morara Moke will deal with multi-choice referenda, registration of voters, presidential immunity, and he will also tackle the cross appeal. Mr. Topua and Mr. Christian Andole will deal with the popular initiative. Your Lordships, we submit that none of the appellants have made a case to overturn the High Court decision. None of their grounds of appeal can be upheld. I would also like to point out that there are some aspects of the judgment that the appellants have not appealed against. Those we have set out in paragraph 6 of our submissions. Then there is also an attempt by the appellants to ameliorate their appeals, their cases, by changing their positions in the High Court and advancing new arguments. Those we have set out in paragraph 10 of our submissions. On public participation, I will not rehash what has been said. I'll only emphasize on the guidelines that were given by the Supreme Court in the case of British America Tobacco versus the Cabinet Secretary for Health. The guidelines are quite a number, but I'll only deal with about 3. The first one is that public participation, being the touchstone of governance, must be real. It should not be illusory. And applying it to the bill that was the subject of challenge, we submit that you cannot tell people that being their representatives, elected leaders, that you can just present a document to them and require of them to append their consent through signatures, and you have not demonstrated to them what the document is all about. You must give them an opportunity to know what is in the document, and you cannot tell them that, oh, no, you just endorse, you will have an opportunity to participate at the referendum. That is not meaningful. Second, you have to be clear on the subject matter. You cannot have a bill which you tell people that, you know, this is my proposal, support it, and they do not know what is in the bill. You have to let them know what the contents are, and this is to be done through civic education. Again, if you have not published the bill in the languages required under Article 7 of the Constitution, how will they even know the contents? So they will not be clear on the subject of the bill. They will not be clear on what they are endorsing. The Supreme Court also said that civic education is mandatory. The only thing that would matter or would differ is the extent because of the importance of the subject. Now, coming to the importance of the subject, amendment of the Constitution is extremely important. It affects all the facets of life for everyone. You cannot compare it with a sector. If I may use the example of pyrethrum, if you want to develop regulations concerning pyrethrum production, perhaps you will consult a handful of growers, processors, and exporters, whom we know are not so many of them. But when it comes to the Constitution, you must involve everyone. You must ensure that you reach everyone, you give them an opportunity that is reasonable to participate in that process. And that means every Kenyan, whether they are articulate, inarticulate, educated or not educated, whether they are affluent or impoverished, they have to be involved. I would also like to make reference to the submission that was made by the Honorable Attorney General that the bulk of the Kenyan population is illiterate, and it would be nearly impossible to involve them so that they may have a say. We ask you to disregard that submission, because that submission is actually very surprising and disrespectful of our people. When it comes to the question of what are these issues that you are taking to the people to endorse, we submit that you need to separate the issues at the point of signature collection so that the supporters are endorsing individual issues. You should not give them a corpus of issues and ask them to endorse. They might be disagreeable to some of the proposals. And by giving them an omnibus proposal, you will actually be disenfranchising them. The other subject that we want to talk about in connection with public participation is the notion of political settlements. Political settlements? Settlements, yes. Settlements that was alluded to by some of the appellants, saying that the Constitution 2020 is a product of political settlements, and people should always cede ground to leaders to determine for them what is good for them. We ask you to disregard that notion and actually discard it. Do not allow it today, do not allow it tomorrow, and even ever to ever prevail, because it will be very dangerous to our democracy. Quickly, I move to the question of the quorum of IEBC. I'll also not reiterate what has been said by other respondents, save to say that, though regrettable, that IEBC does not have a complete composition and it's not quoted. IEBC itself should not be apologetic about it. It should not be defensive about it. IEBC does not constitute itself. It does not fill vacancies for itself. It is only a victim of circumstances. These vacancies rose not 1 year ago, not 2 years ago, not 3 years ago, but 4 solid years. So why haven't they been filled? I believe that is the kind of dream or novel or movie that Senator Orengo was referring to. This is the one in this whole conundrum. And none of the appellants asked that question. Why are we at this place where we do not have a quorate IEBC? Yes. We would also like to point out that IEBC, having been left to be in limbo for 4 years, that's a very dangerous position. The country is actually standing on the cliff. Additionally, these 3 commissioners who are in office, even if they may try hard as they may to discharge some of the functions of the commission, are they representative of the face of Kenya? Because we believe and submit that the reason why IEBC was given wide membership is so as to have inclusivity of our people throughout the Republic.
Yes.
As I wind up my part, I would like to leave you with this quotation that was written by Abraham Lincoln. He said, "Stand with anybody when he is right, and part with him when he is wrong." In this particular case, we ask you to stand with the people, because this time round, the people are right, and they do not want their right, inalienable right, to be snatched from them. At this point in time, I invite my colleague, Dr. Tiangodu, to continue from.
Thank you, Mr. Weaver.
My Lord, I request that the order is to run some.
Sorry?
I want to project.
Sorry?
I request the court assistant to project something I want to show them. The deed run as a setup. Oh, it's on our screen, my Lord.
Where did it come from?
It's part of my presentation, my Lord. They started my clock, my Lord, before I even introduced myself.
All right. Okay.
My Lord, I've been constrained to fundamentally alter my presentation in view of...
Just introduce yourself first for the sake of the record.
For the record, my Lord, my name is Mudomi Thienkolu, representing...
Is it Dr. or Mudomi Thienkolu?
The actual name, my Lord, is Mudomi Thienkolu.
Okay.
It is an element of vanity to say I'm Dr. So-and-so or Professor so-and-so.
I heard that reference earlier. That's why I wanted to confirm.
Yes, my Lord.
Okay.
Now, my Lord, I only mentioned two things in my presentation. One is what I believe should be the overarching questions that should bother you after you listen to all these arguments and counter-arguments. And I suggest those questions are as follows. Number one, your decision, whichever way it will go, you should ask yourself, what type of precedent will it create? Number two, what scheme of incentives will your decision either to uphold the High Court or to reverse the judgment set up? Question number three, which is related, my Lord, is how are future presidents of the Republic of Kenya likely to treat the Constitution if you allow this illegal enterprise and give it judicial imprimatur? How are future politicians and political elites likely to handle our Constitution if you reverse the High Court judgment? Of course, my Lord, I don't know the answers to those questions, but there is a court of wise men and women. I truly trust that the court has the capacity to get the correct answers. The other part of the second part, my Lord, and before I go to the second part, there is a small matter that just crossed my mind. There was this story about Wikipedia. I can tell you without fear of contradiction, my Lord, that the definitions in Wikipedia tally with those in the Black's Law Dictionary and those in the Oxford Advanced Learners Dictionary. So it doesn't matter anyway whether the source was Wikipedia. My second limb, my Lord, is what is on our screen, and I would invite our staff to run the slides as I speak. On that screen is a monster, which is an artistic depiction of a creature from Greek legend in antiquity called the Hydra of Lerna. This monster, my lord, was so virulent, so venomous, that its scent alone could kill from a long distance. It was created by one of the Greek goddesses to annihilate an hero called Heracles. And killing this monster, I don't know why they're not running the other slides, my lord, was one of the 12 labors of a gentleman called Heracles. The challenge, my lord, with killing this monster was that it had about 10 heads, and for each decapitated head, it immediately grew 2 extra heads. Now, this gentleman was asked to kill it. My lord, what I'm trying to say is that the Hydra of Lerna has been roaming our land since the 12th of August, 1897. When this monster came, some of our beloved brothers and sisters, in their wisdom or lack of it, thought it would make a fantastic pet and therefore believed it should be nurtured. Some of our forebearers, of course, did not share that view, and they rose to protest. They include Mekatilili Wamenza, they include Koitalel Arab Samoy, they include Dedan Kimathi, and we could count and count if we had the time, my lord. To cut a long story, my lord, this monster ate our freedom. We were colonized. It ate our dignity. It ate our rights. And we were tenants of the crown in our own land, and basically it ate every fabric of our social, economic, and political identity. We sent our best brains to Lancaster House in London between 1960 and 1963, and their singular task, my lord, was to design a sword for slaying that monster. That sword, my lord, was the Independence Constitution. This magical sword was kept under the custody of the judiciary on the understanding that judges sworn to deploy this sword without fear or favor would deploy it whenever the Constitution was threatened with a breach. The people who wanted the Hydra to drive, my lord, embarked on an enterprise to make the sword ineffective. They were hitting it against a granite rock so that the sword would be blunt 38 times through 38 IPA amendments. At the end of the day, because, my lord, I'm just brushing through things, given how the court has allocated our time, Kenyans kept running to the judiciary. Kamau Kuria ran to the court saying the monster had swallowed his right to travel and liberty. He was told by the courts the passport belonged to the president. Professor Maina Wakenyeti ran to the judiciary to defend his academic freedom, and instead of deploying the sword, the judiciary dropped the sword. I can go on and on, my lord. Anarita Karimi Njeru, Gitobu Imanyara, James Orengo himself, I've seen Dr. Kaminwa. All these people, I could count them until the cows come home. And they kept running to the judiciary, asking the judiciary, please deploy the sword. The monster is about to devour me. And on most of the occasions, because I'm cutting the story, my lord, the various judges, without mentioning their names, invariably trembled and dropped the sword. Before 2010, there were a few judges who, although the sword had been made blunt through hyper amendment, they had the presence of mind and courage to deploy it. One of them was Chief Justice Madan, sitting in that bench called Githunguri versus Republic, with Justice Gishero and with Justice Aganyanya. And they slew that monster, even using the blunt sword. The challenge before you, my Lord, because I can't now present as I had intended given our time has been reallocated, as you ask yourself those questions I began with, Kenyans are watching your decision, not for its intellectual depth, not for its lexicon and how you use the language of the law. What Kenyans are watching is, will the Court of Appeal drop the sword? If you drop the sword, my lords and my ladies, we have been there before. When the courts dropped the sword of the Constitution, we had denial torture chambers, we had detentions without trial, we had sedation laws. It may sound, my Lord, like I'm exaggerating, but the whole thing began in small bits. This is an amendment. I beseech you, my Lord, and your court, and pray for you and your colleagues, that just like Madan CJ, even nearing his retirement, old and frail, you will have the courage, the presence of mind, fidelity to your oath of office, and that you will deploy the sword and slay this monster, this hydra called the Constitution of Kenya Amendment Bill, the year 2020, otherwise known as BBI. Thank you, my lords.
Thank you, Mr. Siankolu. Counsel, introduce yourself, please. Your time is ticking.
Good afternoon, your lordships and my ladies.
Good afternoon.
Thank you very much for the opportunity you've given us to expedite our case. Despite the short time, I believe that justice will be done. On May...
Your name first.
Sorry, your lordship. My name is Morara Omoke. Also has been referred to as the 76th respondent and the petitioner in E416, also advocate of the High Court. Your lordships, when the judgment was delivered by the Superior Court, there was an outpouring of joy all across our nation. And there were a number of reasons why our people were celebrating. One of those reasons was the finding of the Superior Court that whenever we have a referendum in our nation, there should be a nationwide voter registration exercise. Secondly, that we must always have a multi-choice referendum. Those are not findings that were not within the Constitution. I'll be able to show you in a minute that all those findings are well anchored in the Constitution, and the finding that was made by the Superior Court was merely a restatement of what the Constitution provides. So I will begin with the requirement for voter registration. We have discussed at length multiple cases on public participation. From Gakuru, we've talked about the BAT case. We've talked about all those cases providing the principles, setting the standard for public participation. And that is one of the reasons why we must have a voter registration that is massive, nationwide, before we can conduct a referendum. Because this is an exercise concerning the supreme law of our land. We cannot possibly proceed to amend the Constitution without giving each and every citizen who has a right to vote in that exercise. So I will make reference to articles in the Constitution that provide the principles, the electoral principles of our country. So you look at Article 80. I'll ask you, Your Lordships, to read Article 81, 82, 83, and 86. And in a summary, you will see that in those articles, the requirement is that the people must be given an opportunity to participate, because that is their political right, number one. They must also be allowed, if they have attained the age of being able to vote, to be registered. The other thing that you will be able to see from those articles is that the only way you're able to participate democratically in that kind of a process is to being able to vote. And you cannot vote when you're not registered. I will quickly show you that since 2017 up to now, we've not registered. Actually, I'm surprised today I was able to learn that it's not even 108, at least from the latest evidence before the court, which was the affidavit that was filed by the IEBC, where they attached a gazette notice, and they showed you that they have registered, as of December 2019, a total number of voters, 19,678,885. That is as of December 2019. Luckily, there's another record, which is a public record, being a gazette notice number 6251, published on June 27th, 2017, before the last election, showing that at that point in time, we had only registered 19,601,502 voters. If you do a quick math, you will see that the number of voters registered, at least in terms of the number, the increment, whether they were voters who passed on, it's merely about 10,000, about 50,000 voters. Your Lordships, you should be able to take...
That is between 2017 and
2019 December. The difference of when I quickly do it by looking, it's merely about 50 to 60,000 voters in a duration of about 3 years. So that tells you that that order that we sought before the Superior Court was well-founded, and it was actually justiciable. So the arguments that that was not justiciable are completely of no legal basis and of no factual basis. At that point is when I get to comment on the burden of proof. The appellants have made many arguments about the burden of proof, and they said that we were not able to discharge our burden of proof. They forgot to tell you that under Section 112 of the Evidence Act, that there are times when that kind of burden can shift to the party who has special knowledge of the subject under consideration. When we were before the Superior Court, the appellants approached the case in a way that I would use the words of the CJ Emeritus, David Maraga. It's like what he used to call utadu, to mean that he was asking, what are you petitioners going to do about it? When we were alleging before the Superior Court that in our country we were not carrying out continuous voter registration, and the apprehension I referred to in the Superior Court that drove me to raise that allegation was the speed at which we were carrying out the amendments to the proposed amendments to the Constitution. The speed which it's really, it's at the speed of lightning, and you'll be able to look at all the affidavits presented before the Superior Court in support of the petition E416. There was a supplementary affidavit which was not filed properly by the Attorney General, and I was forced to file it as a supplementary record of appeal. And that one I filed on 23rd of June 2021. I was able to give the entire affidavit I filed as a supplementary before the Superior Court, summarizing all the issues that I'd made as allegations in the petition, just to really strengthen the allegations that were made. And I was able to show that the process was moving too quickly, and if we went at that speed, by now we could have had a referendum, was it not for the intervention of the Superior Court, and we would even be here today hearing these petitions. So those allegations I made were more than ripe at that point. But what else can I say about the principle of ripeness? our constitution, as we have seen, is one of the most progressive. And when you look at Article 3.1, it has empowered, and the word used is it uses the language. I'm going to read that clause for the court to take note. So the language uses, every person has an obligation to respect, uphold, and defend the Constitution. You will see that in this particular provision, they did not even say every citizen, they said every person. That means even those who are not Kenyans, who may find themselves within our territory, will be bound by that provision that they must defend the Constitution. What that tells you, my lords and my ladies, is that argument about ripeness and justiciability has been severely reduced when you come to matters touching on the defense of the Constitution. And that's not the only thing. I refer you to Article 22(1) of the Constitution, again, which says every person has been mandated by the Constitution to defend the Bill of Rights whenever they find that that right has been denied, has been violated, infringed, or denied. They have a responsibility to approach the High Court to enforce the Bill of Rights. That's not the only clause I will refer to at that point. I'll ask you to look at Article 165, at clause number 4, that the High Court is empowered to identify an issue as raising a substantial question. That in this case, we were able to establish the petitions before the Superior Court raised substantial questions of the law, and that is how we ended up before a 5-judge bench. So for the appellants to tell you that there were not issues that were justiciable or ripe, that is a serious misapprehension of the law. So that I have been able to establish the basis for voter registration. There's more that we've said on that subject. I'll invite the court to look at what the Superior Court found, and also what we've stated in our submissions. So I'll refer to the court to look at the findings of the Superior Court at paragraph 764 and to 772, where they summarized our argument before them, and they easily reached a conclusion that voter registration is mandatory if you must maximize the participation of the citizens at the referendum. I'll move quickly to the issue of multi-choice referendum. Again, that one finds strong basis within the Constitution. I'll refer to the same articles I referred to again in Article 80, 81, 82, 83, and 86, which touch on the electoral system, the principles that govern our electoral system. Also, we'll touch on Article 38, political rights. Article 33, freedom of expression. If I'm presented with multiple amendments, how do I choose if I'm told to accept them within a binary referendum question of saying yes or no? And luckily yesterday when Justice Kiage raised a question about the provisions of Article 257, it came out very clear that within that article, the law simply refers to amendments in the singular. Bills, it refers to a bill. And our Constitution is not a confused document. Whenever it needs to refer to something in the plural, it has always done that. And whenever it needs to say something in the singular, it has done that. That's why we have the President of the Republic, not presidents of the Republic. That's why we have the Chief Justice of the Republic and the President of the Supreme Court, not presidents of the Supreme Court. So that point was clearly, I think, very well understood, and I will not belabor that point. The other thing I wanted to explain from the submissions of the Honorable, the Attorney General, suggesting that our people are illiterate, they cannot participate in a referendum. I would like to give it a different perspective, that actually that's a very good admission on the part of the states that our people will require very active, a lot of public civic education before they can participate in a referendum. So that should be treated as an admission that the people are not ready for a referendum. But I'll go ahead and say that actually our people were very brilliant when they made those provisions And I've highlighted that within our digest of authorities when I've talked about various documents that can guide the court to reach a conclusion that a multi-choice referendum is actually practical, that the people believe in themselves to make the right choice. And the reason I say that, I'll refer you to the preamble of the Constitution, where they say, we the people give unto ourselves and our future generation this Constitution, so they know that they have the capacity to meet each and every aspiration within this document. So within our bundle of authorities, I'll ask you to look at some documents that we presented. One of them was actually considered by the Superior Court, which was a report of the EU Commission on Referendums. And I saw that there was a complaint about it having been written in the United Kingdom. But I'll simply pose a question to those who have found fault with that report. What is wrong with us doing a comparative study, especially with a country where we have borrowed very heavily in terms of our legislation? What is the problem with comparing with that? And when you look at those reports, when you look at a document I gave in the submissions by Wagner, doing empirical study across 100 countries, Your Lordship and my ladies, kindly allow me to just point out to you where to find those documents within the digest, because I think it's very important. So I will ask my ladies, your lords, to look at one of the authorities I will ask you to consider very quickly. So the first document is to be found at pages 471 of the list and bundle of authorities. That's volume 1. I filed 4 volumes. It's known as Lessons from International Multi-Option Referendum. That's the article, and it's actually a study by Wagner looking at over 100 countries, gives you data showing that a multi-choice referendum is not impossible, and it's not actually an abnormality. It's something that has been done and can be done, and it's the best way. It's the best way to optimize public participation. I'll ask your lordships and my ladies to also consider another report done by the UK Electoral Commission, to be found at page 486 of my bundle of authorities, that gives us a guide, and I think that would be very useful for the IEBC to consider. Kind of gives you a guide on how to design referendum questions.
Just give us the pages. You have said 471, 486, and next.
Your Lordship, let me systematically point out all the documents I've referred to. So the first document I referred to was the one that the Superior Court relied upon, a report of the Independent Commission of Referendums that was published in July 2018, to be found at pages 204 to 427 of the first volume of the 76 Respondents Bundle of Authorities.
Yes.
In summary, in that particular report, I would particularly encourage you to read chapter 8, which discusses this multi-choice referendum concept at length and really affirms the principles I referred to in our Constitution. So as I was saying, it's just a restatement of our Constitution. The second document I'll ask you to consider is to be found at page 428 to 470 of the first volume again. That is known as Referendums in Europe, an analysis of the legal rules in European states by European Commission for Democracy through law, published in 2005. The third document is the one by Wagner at page 471 to 481. The fourth document, my lords and my ladies, is Guidelines for Constitutional Referendums at National Level, adopted by the Venice Commission at its 47th plenary meeting of 2001. Lastly, a document from the UK Electoral Commission, to be found. So the last document from the Venice Commission is at page 482 to 485. The last one is the document prepared by the UK Electoral Commission at page 486, just one page, giving a guideline, and I'll encourage the IEBC to be looking at it as they prepare to implement the finding of the Superior Court. So lastly, because the time is running out, Your Lordship, I'll quickly speak to the cross appeal that was filed by the 76th respondent. It was referred to by our lead counsel, Mr. Nyamweya. So in that particular cross appeal, we are raising a number of issues that we hope the court can consider and make a determination. I'll quickly highlight. I hope Your Lordships and my ladies have that before you.
Yes, we have.
As you can see, we wanted the court, we were praying that the court pronounces itself unequivocally on whether, whenever someone is seeking to amend the Constitution, can utilize public funds. That's one of the issues. In this particular case, we were saying the person behind the BBI initiative was the president himself, and enough evidence has been presented to show that he's the one and none other. And I would quickly add that all others claiming to be the promoters are only agents of the president. They are only now becoming pretenders to the process. Their principle is well known. They are merely agents, and they should not.
There are 8 grounds of cross appeal. You are asking us to determine all of them, eh?
Yes, your Lordships, and my ladies, I ask you to determine all of them.
Okay.
If it will please the court, I would politely pray that you allow one of our counsels within the team to quickly speak on the issue of public funds. You could give him 5 minutes, your Lordships and my ladies, and there will be one more counsel to come on board to discuss the popular initiative also very briefly. If you can also give them 10 minutes, and you can add me 5 minutes to complete my argument. Is that possible?
No, I don't think so. With respect, Mr. Sorry. Morara.
Morara.
Yeah, Mr. Morara Omoke.
Morara, your Lordships. Morara, not Mora.
No, I didn't say Mora. I didn't say Morara.
All right.
I said Morara.
All right.
Yes. It is already past 4:30, precisely almost 20 minutes to 5. We have seen your issues, they're here. So, you can see your time is up. What is your specific request?
So my specific request is you give us 15 minutes, which I'll distribute as follows. I'll give Mr. Topoa Lesinko 10 minutes to argue briefly on the popular initiative, and I'll give 5 minutes to Mr. Andole to speak to the issue of public funds. And as you determine that, I will quickly state that there was an issue that has arisen during various questionings by the judges on how the BBI bill became a bill, and I'll quickly propose for you to consider that the final BBI report is what is contemplated in Article 257 as a general suggestion that was converted to the bill.
Just hold on, take a seat.
Thank you, Mr. President.
Let me see.
Now, Council, we will have to stop at this point, and the 15 minutes you have requested for, we shall consider it in the morning. We are aware that you say you haven't finished, but before we rise, we still have a number of parties through their respective council, as we went through earlier before we started the afternoon session, who must address the court tomorrow. And then we have the reply by the appellants, and we have appeal number 307 by Mr. Charles Kanjama. I will therefore say this. While we respect the rights of the remaining parties, including the Amishai who were specifically cited to address the court, we want you to request that you consult among yourselves and see how you can best apportion the time, because almost all the issues are cross-cutting, so that one or two of you take a lion's share of the time to just run through all the issues. The others may choose to take like 10 minutes, as we did with some of the respondents yesterday. And for the appellants, I want to ask you to put down your responses in form of the submissions that you are to make, and take no more than 15 minutes to make your respective responses. You are 4 of you. I don't see why each one of you should take 30 minutes. We have to revise the time downwards.